kindly sees, your lordship had passed an order on 25th November directing me to inquire about the status. We have obtained a report. The summons was duly served on 22nd of December 2023 to the defendant. 29th of December 2023. So, my lord, I will be praying, my lord, for passing of orders to make the suit ex parte, my lord, so that I can proceed.
Not appeared on 10th.
No, my lord, it appeared, but it is appearing way below, my lord. That is why I'm mentioning. It is appearing way below in the list, my lord. That is why, my lord, I'm mentioning, my lord, for making the suit as ex parte.
It is appearing in the list, na?
Yes, my lord.
Number? What is the serial number?
We have item number. Lord, I shall give my lord the number, my lord. I shall give my lord's court officers the number. Extremely grateful.
Your lordship, a probate application was filed. The department has already completed the scrutiny and the matter is ready for hearing. So I would request your lordship to please list the matter for hearing.
For what?
For grant of probate.
Yeah. Consent filed?
Yes, sir.
Citation completed?
Yes, consent completed.
Your lordship, if I may be permitted to mention a matter, it's a testamentary suit. Honorable Justice Apurva Sinha was pleased to direct the matter to be listed as a testament witness action on 17th of June 2024.
Witness action?
Yes.
Contested
Everything
suit?
is completed, but
Testament, the contentious cause?
Yes.
Who is for the other side?
Mr. Rahul Karmakar, we have served.
How many witnesses you are having?
I
Witness
do
started
not
not? Not yet started. Witness started or not?
No, nothing is started.
How many witnesses you are having?
I do not have that instruction, my lordship.
So you take instruction, inform the other side, let both the party come.
We have informed. Everything is completed, my lordship.
What? When you informed? Give this?
All formalities have been completed. The matter is otherwise ready.
Now, when you inform the other side, you will mention the matter today.
Yes. We have informed on
11th.
5th of December.
11 December you informed.
No, 5th of December we have informed. The matter was listed. We will mention it on 12th. We have
Wednesday to be mentioned.
My lord, may I permit to mention one matter, probate matter, my lord?
Who is
Scrutiny
senior? Yes.
My lord, scrutiny is complete.
Hmm.
So consent given, you ready with the files. Now the matter will be listed for final disposition.
Yes.
My lord, may I be permitted to mention a matter? My lord, I am seeking leave to draw up the order that disposed of 2 GA applications in 2 analogously heard matters, my lord.
When it was passed? When
My lord, 18th of November 2024.
Till date it has not been. You are not applied for.
My lord, we had applied for the certified copy of the order. However, it needs to be drawn up, my lord.
Give me.
My lord, may I be permitted to mention another matter?
Yes.
My lord, it's a non-contentious testamentary matter, my lord. The interim order was passed on 4th of October 2024. However, my lord, the extension...
Testamentary matter?
My lord had directed...
This cause non-contentious cause.
Non-contentious, my lord. My lord, my lord had directed the respondents to maintain status quo on the assets. We did the order dated 4th October 2024. My lord, however, the extension does not...
Give the order.
My lord. My lord would kindly go to the last page, my lord, second last paragraph.
Yes.
My lord,
I think some order was passed by this court also.
Yes, my lord. Yes, my lord. And my lord had directed the extension of interim order, however, it did not appear on the records.
Yeah. Yes, then what has happened now?
My lord,
What do you want now?
my lord, I'm humbly praying that the order be modified to the extent that the interim order is extended.
You not prayed for interim order.
My lord, we had prayed for the interim order. My lord, on the last occasion, we checked it on live stream also. My lord had dictated, but however, it did not come up on the order copy. My lord had dictated that let the interim order be extended until further orders. However, inadvertently, it did not appear on the order, my lord.
The status quo effect shall be considered after service of notice. Direct to maintain status quo with respect of
My lord.
as mentioned in the affidavit asserts until further order.
My
Until
lord.
further order.
My lord, that is 4th October. Subsequently, there was another order.
To 4th October. 4th October. Then 28th November.
Right, my lord.
28th November. So it is until further order, until the order is vacated. It is until further order.
My lord. My lord.
Correct. It is until further. It is not a date till 4th October. Until further order means unless it is vacated.
My lord. My lord. Grateful, my lord.
Lordship, may I be permitted to mention a matter wherein your Lordship was in a GA pleased to observe that to return the plaint on the ground whether it's commercial or non-commercial. Your Lordship, I was only praying leave from your Lordship that the court fees also be returned so that your Lordship, otherwise I have to file before the commercial division.
On merit. On merit. That's
So
why
that's
keeping in mind I passed the order, sir. Sorry.
very,
If
very
it is the
Lordship.
very first day, the court allows. But on merit, after affidavit, it is not.
Very well, Lordship. Great.
Please be permitted to mention one matter, my lord. In this matter, my lord, yesterday my lord was directed to serve notice upon other side. This is ATA 4, my lord. ATA 4 of 2023, which is disposed of by order dated 12/7/24 by the Honorable Justice Shubhra Ghosh, my lord. This is the last order. Appeal disposed of and.
Now what you want? Accordingly, modify the judgment and order dated so directing the application would be pending. The decision of the board shall be placed on record. So what you want now?
For listing, my lord.
After the appellate court order.
Yes, my lord.
ATA. Who is for the other side?
I have mentioned, my lord.
Have you mentioned?
Serve notice, my lord.
ATA. Wednesday or Thursday. Right?
Lordship, may I permitted to mention two probate application, my lord. One has been KVS.
Senior is there. Seniors are there. Please maintain seniority. Yes.
Lord, I mentioned therefore last. Lord,
Lordship, may I permitted to mention two probate application, my lord. One has been citation was issued and other was caveat and service was done, my lord. And
So what you want?
for inclusion, my lord.
Give the list. Inclusion of the testamentary, give all the list to my court officer, it will be listed. Yes, sir.
my lord, that faithful matter, Miller, my lord had extended 4 weeks' time. We have received affidavit in opposition only yesterday from defendant number 1. Defendant number 4 is still, we have served notice, Miller, let it be appear as to be mentioned, Miller, tomorrow, so that Miller to get.
Tomorrow is
my lord, whatever subject
it
to
is the non-commercial matter. No?
non-commercial, Miller. On the
Wednesday?
yes, Miller, I shall.
Wednesday to be mentioned.
Lord, may I please mention my injunction application in a suit where Lordship has, my lord, allowed me to present the plaint. This is, my lord, that matter where the plaintiff is 92 years old, duped by his developer, who on the basis now for revoked power of attorney, my lord, is continuing to create third-party rights. My lord, there's some urgency. My lord, any date might be taken up as per.
Non-commercial?
Non-commercial matter, my lord.
Good.
It's been filed and even the plaint has been presented.
Ad
interim, my lord. And your Lordship has granted leave under order to rule. Grateful.
My lord, may I be listed in Wednesday new motion.
Grateful, my lord.
My lord, may I be permitted to mention one matter for upgradation minor of monthly list item number 11.
Why
of original
upgradation,
site.
sir?
My lord.
Why upgradation? What is the necessity?
My lord, the matter is pending, my lord. Since
What is the matter about?
My lord, ATA 7 of 2024.
Yes, what is the matter about? What is the urgency?
My lord, kindly
Tell me the urgency, then the court can pass an order direct to upgrade. Tell the urgency. What is the urgency?
directed to mention the matter. My lord, my senior requested me to mention
Tell your senior to give the what is the urgency is to be pleaded before the court, then the court will allow. Tell the senior. Who is your senior?
Saroshish Dasgupta. Saroshish Dasgupta.
Tell your senior what is the urgency court has asked for. Please come with the urgency, then we will court consider. Correct?
I'm the plaintiff. This
I
is
am for the defendant caveators.
Yes. Why to be mentioned?
I'll tell you, Lordship. This is a contested suit for grant of probate. Now, my lord, on 8th of December, on
20th August.
20th August 2024, an order was made directing discovery. And my affidavit of documents is ready, but it was out of time, so I was seeking leave to file it beyond time.
Discovery completed.
Mine is completed. They have not filed, so their time has to be extended, my lord. And I was praying that the suit, along with all the applications, can appear in January.
We have not received any documents from the plaintiff's side by which we will be taking inspection. So discovery and inspection is not complete from the plaintiff's side. My learned friend perhaps is submitting affidavit of documents.
That is what I said.
Those documents which they
in my limited understanding, by discovery, we only mean affidavit of documents. Inspection would be after I'm given leave to file this. I will supply this to him along with a copy of the documents, and then he will take inspection.
You have disclosed the document.
Yes, kindly give me.
Original.
No.
Original documents is for them to take inspection, my lord.
That's why.
Yes, so, but first I must have leave to file this.
So?
Yes, my lord, they will let them disclose. They are disclosing now. Let both the advocates on record, my lord, decide when they are going to take
No, you have to complete. You don't want to disclose any documents.
I'll disclose the documents, the original documents directly.
How can that happen?
And after that,
he has to file an order 11 rule 12. He has to file a affidavit of documents.
For the plaintiff, appearing for the defendant, the matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff. Counsel for the plaintiff submitted that this court has allowed the parties to complete the discovery and inspection of the document and to file affidavit of documents. So counsel for the plaintiff submitted that his affidavit of document is ready, and if this court will permit, he will file the affidavit after serving the copy to the learned counsel for the defendant. Learned counsel for the defendant submitted, he will.
I have received the affidavit.
Counsel for the defendant submitted, he has received the affidavit of document from the plaintiff and submitted, he will disclose the original document to the plaintiff for inspection.
Yes.
Considering the submission made by the counsel for the parties, though the plaintiff has already disclosed their document by filing the affidavit documents, the defendant is also directed to disclose their
document. May I interject? Plaintiff has not disclosed the documents to us.
No,
yet.
I am coming on that. The defendant is also directed to disclose their document by way of affidavit document, and the plaintiff is directed to disclose the original document to the defendant for inspection. Simultaneously, the defendant shall also disclose the original document to the plaintiff for inspection. Let the process be completed within a period of 2 weeks after the winter vacation. In the meantime, the parties are also directed to exchange their suggested issues. List the matter on 22nd of January 2025 for framing of issues.
Well, this is, my lord, with respect to the testamentary suit. There are also, my lord, 4 applications. And one of the applications, my lord, for removal of the executor, which is, my lord, listed today. It's there in the list. But may that remain in the list for your lordship.
I am not touching the list. I am only with regard to the mention.
Your lordship will also fix all the applications for hearing on the 22nd.
That's, my lord, joint prayer.
Okay, let us see.
Well, let it be there in the list if it reaches. I'm deeply obliged.
Number 2. Item number 2.
Not today.
Item number 3.
Not today.
Number 4.
Item number 4, I will for the executive petition, my lord. This is an application seeking a direction upon the bank manager, my lord, to inspect, open the bank locker and to inventory the assets lying over there, my lord. But they're the G1.
What is the application for? Have you filed any application?
Yes, my lord. It is GA1, appearing as GA1, my lord. It is listed.
GA1 has come? No. You have given the requisition, but they are not sent. Call the registrar, friends. That's why. Call. Paso. Call the registrar.
File number 5.
Item number 5, I beg to appear for the trustees and petitioners. And on the last occasion, my lord was pleased to direct and pleased to observe that it would be better for the parties that if the trustees bring the total expenditure regarding the devoted trust and what are the interest rates that is provided by the different banks in the fixed deposits. My lord, I have come up with after I have sat for 2-3 occasions with the trustees and the expenditures, my lord, is showing that is for half yearly, that is 10 lakhs 39,000, and interest rates if calculated on 3 crore 51 lakhs on 7%, but they are proposing in Axis Bank, Yes Bank or on UCO Bank. These are the interest rates. These are all 7%. And if it goes more than 3 crores of rupees and for an up to 5 years, 3 years to 5 years, then they are all providing 7% interest. That is, they can actually withdraw the interest half yearly. And that calculation has also they have made that if they calculate 7% on the total deposit they are making, that is 3 crore 51 lakhs, that is coming 12 lakh 28,500, that is half yearly. And there are other properties they have mentioned that 116, 117, 117 1 Lenin Sharoni, and there are expenses for renovation repairing of those premises that will amount to 18 lakhs to 20 lakhs. My lord, kindly pass
Trustee remuneration 15,000 per month.
Yes.
And puja expenses 2,000, 2 lakh 5,000.
And that is their annual puja, Durga Puja. Durga Puja, it is total at 30 SN Banerjee Road. Yearly, it's around 4 lakh 10,000. That is, they call all the relatives and everything. It's a big event for them. And now I leave it to your lordship how much they can withdraw. I have provided the interest rates and provided the expenses actually what trustees have handed over to me. And now my lord will decide that how it will be.
Mandir maintenance, then thereafter the general maintenance, then Nitya Puja, you have segregated all these things. Mandir maintenance will come along with the Nitya Puja and all these things,
Yes,
electricity. How it can be, sir?
And building maintenance of 116, 117, 117 by 1 Lenin Saroni. And these are all half yearly calculated.
That's why.
And those are all dilapidated and those are all various litigations are also pending in different trespasses and all. And it's up to your lordship, my lord, how lordship will ask them to actually withdraw from the interest portion and let them fix deposit for 5 years and let there be an if they come up with a proper application before this court for withdrawal of that money, they will prefer an application and they will actually seek permission and seek leave of this court before withdrawing that money. And if whatever my lords feel fit, my lord can grant that. My lord, it is up to your lordship. It's totally up to your lordship. And the interest rates of Yes Bank and Axis Bank, I have provided, that is 7%. Even UCO Bank, where the trustees have their accounts, that is also providing 7%. And they are wanting that to actually request your lordship to open it in the Axis Bank if possible.
And the court will, it is your choice to which bank you maintain.
Or if Axis Bank will be better for them.
What will be the benefit? What is the State Bank?
State Bank is also actually 7%. They are not here for State Bank. They don't want to go for State Bank.
Yes.
My lord, I do not have anything else to add on to what my learned friend has said. Lordship, the only typographical error which has creeped into the last order, Lordship would remember that there was this dispute, there was this issue with respect
That
to
is
naming.
corrected, I think so.
Lordship, what has happened, if I may kindly indicate, I have also written it down. It was passed on the last occasion. SIBDELANE, and Lordship even is known as SHIBDY, it should be instead of DE only. DEY. That is the only. And Lordship can direct us and give us an outer limit within which we will execute the deed of conveyance and make over
How
the.
much time it will take?
Generally, a query is valid for 30 days. Generally,
Usually,
query.
Lordship, what happens is
When a query is generated for registration of any deed, then it is valid for 30 days. So I think the exercise will be completed within 45 days upon making payment of the entire consideration left to be paid to the.
So I will pass an order to file a report after all these things, execution on conveyance date and the fixed deposit and all those things. The report is to be filed by way of an affidavit by the petitioners. By how much time? 3 weeks or 4 weeks?
Lordship, if I may humbly submit, Lordship, since it takes around 45 to 50 days, Lordship, somewhere around end of February, I think by that time we should.
8 weeks it will be
My
completed.
lord, my 8 weeks.
The petitioners, being the Sibayats and trustees of the deity Sri SRI Ishwar Sridhar Jeev. Full stop. The petitioners have filed the present application before this court, seeking leave to sell the property being premises number 1, 2, 3, 4, 5 and 10, situated at SIB DED LANE Lane, also known as SHIB DEY LANE Lane, under PS New Market, Ward number 46, Kolkata 700013. Full stop.
1897.
The petitioners relied upon the certificate issued by the structural engineer dated 21st of June 2024, wherein it is mentioned that the building buildings standing on the aforesaid property appears to be more than 60 years old, and due to lack of maintenance and age, the present condition of the buildings is very poor within bracket part, which resulted in deterioration plus aging of the materials and structural components, leading to corrosion and cracking. Full stop. The petitioners have also relied upon the valuation certificate issued by the valuer, wherein the total value of the property has been shown as 12 crore 31 lakh 56,313. But due to the condition of the building and the illegal occupation of tenants, the valuer has assessed the market value of the present building at rupees 2 crore 59 lakhs. Full stop. The municipal corporation, the Kolkata Municipal Corporation, has also pasted the notice in the said on the wall of the said building, indicating that the building is dangerous. The petitioners submit that the income of the trust is rupees 1,30,000 per annum, but the expenditure of the property is day by day increasing, and at present the trust is going to losses, which is much higher than the income of the trust. Full stop. The petitioners says that the trust is not in a position to maintain the building, and as such they have taken a decision to sell the property, and from the sale proceeds, the petitioners will use the said amount for the benefit of the trust. Full stop. Paper publication was made.
Yes, ma'am.
Full stop. Yeah. By the order of this court.
Yes.
By which order?
Lordship, the order of 27th September, it was directed that a paper publication be made to call for.
Full stop. When the petitioners have filed the present application, the petitioners have submitted that one AKSA capital K capital S Treasury Management LLP has come forward to purchase the property along with the possession of the tenants and the illegal occupiers over the property for a total sum of rupees 3.51 crore, which 51 crore. Full stop. Full stop. Though this court no, there is no order for the publication.
My lord, that is 27th September 2024, my lord.
But I have filed my affidavit to that effect also, that newspaper publication has been made.
Lordship, if I may kindly read it, it is at page 3 of that date. Order of 27th, it is stated the petitioner being the trustees of the property in questions are directed to publish the notice for sale in the aforesaid.
By an order dated 27th of September 2024, this court has directed the petitioners being the trustees of the trustees to publish the notice for sale of the above mentioned premises in the English daily newspaper, the inward comma Statesman, and Hindi daily newspaper Tanmag once in a week by mentioning the base price of the proposed purchaser as rupees 3.51 crore. 51 crore. Full stop. In terms of the order passed by this court, the petitioners have published the notice for sale in the newspaper and have filed the affidavit disclosing the newspaper showing that the petitioners have published the sale notice. In spite of publication of the sale notice, none has come forward other than the proposed purchaser, Mrs. AKS
Treasury Management
LLP for a total sum of rupees 3.51 crore.
20%.
Full stop. The Treasury Management, the said proposed purchaser has also deposited the 20% of the proposed price of rupees 3.51 crore. That is an amount of rupees
70 lakhs 20,000.
70 lakhs 20,000 by way of demand draft.
By way of demand draft.
By way of demand draft.
Dated 13th November 2024.
Dated 13th November 2024, which is kept with the office. Check and demand draft kahan rakha hua hai?
In the name of the trust, my lord.
It is in the court.
Yes.
It's kept in with the record. Full stop. Full stop. Now the proposed purchaser is ready and willing to purchase the total sale price and purchase the aforementioned property for a total sum of rupees 3.51 crore. In spite of publication of the sale notice, none has come forward to purchase the said property. Accordingly, this court has no other option to accept the rate quoted by Messrs. AKS Treasury Management LLP for a total sum of rupees 3.51 crore. Full stop. The counsel for the petitioner has brought to the notice of this court has submitted the draft deed of conveyance entered between the petitioners and the proposed purchaser, as well as the rate of interest of the banks, namely Axis Bank, Yes Bank, two banks,
madam.
namely Axis Bank, Axis Bank and Yes Bank. The petitioner has also handed over the copy with regard to expenses of the petitioners on quarterly basis, wherein the petitioner said that if the amount is deposited in the fixed deposit and the amount of rupees 3.51 crore is deposited in the fixed deposit in the said banks, the petitioners will be entitled to get 7% interest.
Half yearly.
7% interest, and half yearly they will get an amount of rupees and half yearly they will get the interest of rupees 12,28,500. Counsel for the petition further submit that as per the calculation made by the petitioners, being the trustees, have calculated that their half yearly expenditure would be rupees 10,39,000 for the said trust, for the maintenance of the said trust. Counsel for the petitioner submit that if this court will accept the proposal of the proposed purchaser, the petitioners will execute proper deed, and on receipt of the said amount of rupees 31.5 crore, the said amount will be invested in the fixed deposit, and the petitioners will only invest the interest part of the said amount for the purpose of maintenance of the trust, and will maintain proper account with regard to the expenditures of the trust. Consider the submission made by the counsel for the petitioner, peruse the materials on record, and the proposal of the proposed purchaser. This could find that as per the report of the structural engineer, the building in question is in dilapidated condition and is 60 years old, and the petitioners are not in a position to maintain the said building. It is also found that there are several tenants, and the portion of the premises has also been occupied by the illegal occupiers. The petitioner says that the petitioners are not in a position to take appropriate steps for eviction of the illegal occupiers, and also not in a position to maintain the building due to the shortage of fund. The proposed purchaser is ready to purchase the said land for a total sum of rupees 3.51 crore, along with the possession of the tenants as well as the illegal occupier. This court, considering all the aspects, all the circumstances mentioned above, is of the view that the amount quoted by the proposed purchaser is more than the present value of the property as mentioned, as assessed by the valuer taking into consideration of the age, occupier and illegal occupier of the building. Accordingly, the amount proposed by the proposed purchaser to purchase the property for a total sum of rupees 3.51 crore is accepted. Full stop. Subpara. The petitioners are directed to take necessary full stop. The proposed purchaser has already deposited the 20% of the amount of 20% of the total purchase amount, that is an amount of rupees 7 lakh
70 lakh
70 lakh
20,000.
20,000 by way of demand draft. Thus, the petitioners are directed to take appropriate steps for execution of conveyance deed after completing all formalities in favor of the proposed purchaser. Full stop. The purchaser is also directed, the proposed purchaser is also directed to cooperate with the petitioners for registration of the sale deed and registration of conveyance deed with respect of the aforesaid property. Full stop. Counsel for the petitioner as well as the proposed purchaser submit that it for registration of conveyance deed and for completion of the all formalities, it will take about 6 to 8 weeks. Accordingly, 10 weeks is granted to the parties to complete the registration of conveyance deed. Full stop. Though the proposed purchaser has deposited 20% of the total sale price by way of demand draft, the remaining amount shall be paid by the purchaser to the petitioners on the date of execution of the conveyance deed. Correct?
Yes, my lord, by the date, because sometimes
by the date of registration of the conveyance deed. Full stop. Number next. On this full stop. Initially the petitioners full stop. The office is directed to hand over the demand draft of rupees 70 lakhs 20,000 to the petitioner by proper identification and after proper receipt duly identified by the advocate on record of the petitioner within a week from date by keeping the Xerox copy of the said demand draft on record. On receipt of the said demand draft, the petitioners shall invest the same in a fixed deposit in either any of the bank which the petitioners will get higher interest. Full stop. After receipt of the total sale consideration, the said amount shall also be invested by the petitioners in the fixed deposit carrying highest rate of interest of any of the bank. Full stop. The petitioner shall be at liberty to withdraw only the interest part on quarterly basis for an amount of rupees 7 lakh. The petitioners shall not allowed to withdraw any amount more than the 7 lakh, and the petitioners shall not touch the principal amount principal amount of rupees 3.51 crore without the prior permission of this court. Full stop. The petitioners are directed to maintain proper account with regard to withdrawal of the interest part on every quarterly and shall quarterly or half yearly? Half yearly करो, quarterly नहीं आएगा. Half yearly है ना, half yearly and क्या बोला? Shall maintain the account with respect of receipt of the interest from the bank half yearly and also shall maintain the account with respect of the expenditure, quarterly expenditure made by the petitioners after withdrawal of the interest from the set fixed deposit amount. Full stop. The petitioners are directed to submit the report before this court after before 10 weeks are you given, na? Yes, ma'am. 1 week. Submit the report on 27th of on 6th of March 2025 by disclosing the conveyance deed, fixed deposit details and interest, if any, withdrawn by the petitioners. Let the matter appear on 6th of March. Na?
Lordship, in the very, I'm sorry, Lordship. In the very first page of the order, my lord, I think the name of the estate has gone as
SRI.
It should be SHRI.
SHRI. That is
because that is the name in which they maintain the bank account.
First, na? Shri.
Lordship, may kindly refer to the last order, Lordship.
SRI.
Lordship, the fifth
Shri है ना? SHRI. Shri Ishwar Sridhar Ji. SHRI.
Let the spelling be taken from the order dated 5th of December 2024.
2024 order देख ले.
এটাতেই প্যান কার্ড আছে, এটাতেই কিন্তু প্যান কার্ড আছে। না না দাদা তুমি বলো।
ठीक है ना कैसे पैन कार्ड से ओ उसमें हम कर दे उसमें जब हम बोला ना ऑफिस इज डायरेक्टेड टू रिटर्न ठीक है तो बोला ऑफिस इज डायरेक्टेड ठीक है okay next
I'm grateful
87 कोलकाता ওটা করে দেয়
87
what is going on in the testamentary department can I initiate a disciplinary inquiry what is going on in the testamentary department
as 7 lakh 13 7 it should be 87 13 is where the deity is presently located. It should be 87. It is also written in the previous order. Instead of 13 it should be 87 in the very first page. premises number 1, 2, 3, 4, 5 and 10 of Shipday Lane, PS Newmarket, Kolkata 700087.
Please, Your Lord.
I'm grateful. my lord.
Grateful.
My lord, my lord, my lord, my lord. That would be absolutely. I'm grateful, my lord. I'm grateful.
And regarding expenses portion, 10 lakhs, instead of 10 lakhs, my lord has allowed 7 lakhs. Absolutely.
Correction to কাছে
Lord, I appear for the plaintiff, my lord.
Your Lordship, I am appearing on behalf of the
Lord,
defendant.
that matter, my lord,
Your
when my lord, the
Lordship,
defendant number 1 has taken out an application for rejection of the plaint on the ground of territorial jurisdiction. Lord, this is my suit for, my lord, anti-suit injunction, my lord, restraining them from proceeding, my lord, within the California suit, my lord. With regard to, my lord, the last date, my lord, I have completed my submission, my lord. Only one point, my lord, which, my lord, I thought, my lord, it is necessary to point out, my lord, they have taken out this application on the strength of a, my lord, a power of attorney executed outside India, my lord.
Your Lordship, I am being led by Mr. Banerjee. I am praying for a short passover. He's on his
May I
legs.
just indicate, my lord, the point, my lord? It is, my lord, the strength of a power of attorney executed outside India, my lord. Now, my lord, I have in the opposition had taken a point that, my lord, the power of attorney is not properly executed. They have disclosed that in their reply, my lord. But, my lord, say under section 18 of, my lord, the Stamp Act, my lord, the power of attorney executed outside India needs to be stamped in India, my lord, within a period of 3 weeks, 3 months. Lord, I don't find, my lord, if your lordship see, my lord, their power of attorney at page 31, which they have disclosed in affidavit in opposition of their opposition in GA2 of the opposition file. It's, my lord, it's and corrected in the reply GA2, my lord, in the reply of, my lord, affirmed by Lord, your lordship see, my lord, that is the power of attorney they have disclosed on the strength of which this application has been taken out. Lord, nowhere it has been stamped in, my lord, in West Bengal, which is required, my lord, under section 18, my lord, since it has been document other than, my lord, a promissory note or, my lord, bill of exchange. Page 31 of, my lord, the reply. It's a Lord, it has been executed in state of California. My lord, it has, my lord, you will see, my lord, on page 32, it is executed on 14th August 2024. My lord, as per, my lord, section 18 of the Stamp Act, my lord, any document which is, my lord, executed, my lord, outside India needs to be stamped in India, my lord, within 3 months from the date first coming of the receiving the documents in India. My lord, that has not been done, my lord. That is probably, my lord, as a technical defect with regard to, my lord, maintaining this application. My lord, section Stamp Act. My lord, if you lordship see, my lord, it says instrument other than bill and notes executed out of India. Every instrument chargeable with duty executed only out of India and not being a bill of exchange or promissory note may be stamped within the 3 months after it has been first received in India. My lord, where any such instrument cannot, with reference to the description of the stamp prescribed, therefore be duly stamped by a private person, it may be taken within the said period of 3 months to the collector, who shall stamp the same in such manner as the state government may, by the rule prescribed, the stamp of such value as person of so taking the instrument may require and for pay it, my lord. So, my lord, this document requires to be stamped, my lord, before it could have been, my lord. My lord, I have, my lord, in my affidavit in opposition at page 3, my lord. They, since, my lord, in the application they have not disclosed. I have taken a point of, my lord, page 3 of my opposition, my lord, GA2, paragraph 6. It says, my lord, I have in the opposition, my lord, I have filed an opposition against 3, my lord, paragraph 6. My lord, said it is denied that Shreya Shah is an authorized representative of the defendant on the strength of a power of attorney executed by the defendant number notary at Sunnyvale, California on 7th August 2024. As added, I further said no copy of the said purported power of attorney has been disclosed by the defendant. I call upon the defendant to disclose. On that basis, may I have disclosed, my lord, this power of attorney which I have shown, my lord, at page 33.
Lord, may I make one humble submission with respect to the power of attorney? Need not be seen at all. I am only relying on the plaint. The Lordship will not even consider my application.
They are moving the application.
No, I need not move the application. The court on the very first instance has been misguided by one paragraph, last paragraph showing jurisdiction. That Special Marriage Act, marriage took place in Kulti, that's why this court has jurisdiction. Let us address our point on this. And I'm, as it is, my lord, denying what has been stated with respect to insufficient stamping. My lord, I am. Yes, she is an authorized representative. My lord, the deponent. Yes. That is, my lord, the point he is raising because I was made to file an application. I leave it to your lordships. My lord, these are curable defects. My lord, let me consider this and come back. I need to check it. My lord, lordship will give me a day's time. Let me see, my lord, what is the provision and to what extent this, even if it is considered as a defect, everything can be cured with respect to stamping. Lordship will give me a day's time. Yes, I will. Original touch. Original touch. 90. Deeply obliged, brother. Grateful.
My lord, this is my application, my lord, and for the executed petitioner, my lord. But this is an application seeking a direction upon the bank manager of the bank, my lord, to inventory the locker of the deceased, my lord. Unless the inventory is done, my lord, no, my lord, no. This is the first time appearing, my lord. Well, it is in the record, my lord. Yes, my lord. Yes, my lord. Madam, I have to take instruction regarding the particular specific account number, my lord. I need to take instruction, my lord.
Locker number, but that locker number is not mentioned as the asset of the property. It is
That in even my lord, after the inventory of the account, my lord, the affidavit has to be amended, my lord. So, my lord, if leave be granted, my lord, to correct the, my lord, amend the. Bank lo correct na details देवा नहीं. Phone account की पर account number देवा नहीं. Bank lo correct नहीं. Mention करते हुए तो काम deposit lock करना होगा. এখানে দেওয়া নেই. কোথায় বল? ব্যাংকের নাম লকার ডিটেলস দিতে হবে. ব্যাংক লকার ভ্যারিং দিতে হতো. এটা তো এখানে থাকবে.
Item number 12. Right to appear for the plaintiff. This is a suit, my lord, for eviction and recovery of possession, my lord. The defendant is illegally occupying a suit property, my lord, located at a prime location. Now, we have taken out a chapter 13 in application for a summary judgment because she does not have a defense to this. A suit under 2G, my lord. Original tenant has died, the daughter-in-law is in possession. Now, what has happened, my lord? The defendant is taking out one after the other frivolous application. Now she has taken out first she took out a order 7 rule 11 that's pending. Now she has taken out another application just to stall the suit. Now she wants that the suit should not be marked as a uncontested suit. She wants certain directions, many things. I'm for the plaintiff.
I'm for the defendant. This matter is pending. And if your lordship kindly looks at the order sheet, your lordship will find they did not appear in the plaintiff were not at fault, they did not appear before the honorable court, on several occasions, in the last few days. And we were always present there. They did not file their affidavits also, they did not complete their affidavits, On the other hand, we have filed the order 7 rule 11, which is also pending for adjudication, Now we have, in the meantime, what they have done, they have placed, this is a shop room, and there is a pathway, leading to the shop room. They have placed an old junk cooler, I have given the photographs also, and that is causing a breeding ground to the mosquitoes.
4 applications are pending. GA1 is an injunction application, which we moved at the very inception. In interim granted, thereafter it got discontinued. Thereafter, IAGA 5, which is an application under chapter 13A, my lord. Thereafter, my lord, he filed an application for order 7 rule 11. That's pending. We will not file any affidavit to that application. And there is a new application, IAGA 10, where he is seeking certain direction. The first order 7 rule 11 has to be heard, my lord.
Yeah, the only prayer, is that the old junk cooler has been placed, but I have the photographs, Only prayer is to remove that old junk cooler which is blocking the way, It is causing a obstruction to the
10 miles.
10.
ইয়েতে ফিক্স ছিল মানে অপোজিশন রিপ্লাই হয়ে গেছে ইয়েতে
9টা বলো
9টা বার কর
9টা বলো frivolous application for
9টা কি
ওটা আমারটা যেটা রিজেকশন অফ প্লেন
This is order 7 rule 11. This is my application.
Absolutely. We will not file any affidavits, man. No requirement in filing affidavits in order 7 rule. I will see the plaintiff and will decide. Let him place his order 7 rule there.
The affidavit direction ছিল affidavit direction ছিল
এগুলো ফাইল করার উপরে ফাইল করব না আমি মূল থেকে প্লেস করব
and the printed copy এই
ওটাই আসছে
মামলা এটা আমাদের কি
ওইটা আমাদের জি
Yes, ma'am. I'm placing it. Now, this suit has been filed. If your lordship kindly looks at the plaint, the plaint has been annexed, my lord, at page 44. A degree for eviction of recovery of khas possession of the suit property, more particularly described in Schedule A and B hereunder written, by evicting the defendant therefrom. A decree for mean profit, and yes, Lord. And the grounds, Lord, kindly see, Lord. They are saying that, if your lordship kindly comes to paragraph 4, the plaintiff states that after the death of the original tenant, that is Satyaranjan Kundu, on 24th September 1998, the tenancy was transferred in the name of widow Durga Rani Kundu, and thus the said Durga Rani Kundu became the monthly tenant of the suit property at the rental of 2310 payable according to English calendar. The said tenancy at all material time was governed by the provisions of West Bengal Premises Tenancy Act. The plaintiff states that Durga Rani Kundu expired on 27th May 2015, leaving behind her son Probir Kumar Kundu as his only legal heir and representative. Probir Kumar Kundu was ordinarily living with the said Durga Rani Kundu up to her death as a member of her family and was dependent on her, and Probir Kumar Kundu, being the said original tenant, was deemed tenant of the said suit property for a period of 5 years from the death of original tenant Probir Kumar Kundu. So they had taken a plea that 5 years, 2G. The plaintiff states that the period of more than 6 years has expired after the death of tenant Durga Rani Kundu. The plaintiff states that due to the death of original tenant Durga Rani Kundu and upon the expiry of the period of 5 years and the death of this original tenant, the tenancy has now come to an end, and the defendant, being the daughter-in-law of the original tenant, on and from 27 May 2020, has no right or authority to occupy and possess and enjoy the suit property. The plaintiff has never accepted any money on account of occupational charges or otherwise from the defendant. In such circumstances, the cause of action, now they are saying. Now kindly see, my lord, one thing. What is a suit property? That is also described in paragraph 3. And thereafter in the page 46. Before that, if your lordship kindly comes to page 46, paragraph 3. Originally, one Satyaranjan Kundu, since deceased, was the monthly tenant in respect of one godown measuring about 264 square feet and one wooden structure godown with tin shed measuring 348, situated on the ground floor of the said property, more particularly described in Schedule A and B hereunder written, and is hereinafter referred to as the suit property. Then come to the schedule, my lord. At page, my lord, 52. Schedule A is all that one go down along with a side space measuring an area of 264 square feet. Yes, no, same schedule. Our contention is not that this Schedule A is a shop room and Schedule B is a annexed go down. Sorry. We have given documents also to that effect, not. The documents are there. that it has been rented out as a shop room, and in that event, 2G does not apply. 2G applies in case of premises which are let out for residential purpose only. This was the defense we have taken, and this was the reason this application was filed. And in that event, this suit is not maintainable. They ought to have filed a suit for eviction on other grounds and not on 2G. This is the ground note, and the documents are there right from all rent receipts, and everything will show, my lord, that it is a shop room. The trade licenses are there, my lord. Jashoda Stores, Durga Rani Kundu, at page 21 of the application, my lord. Yes, my lord. And also from the plaint, it will be seen, my lord, without going through any other document. And also the documents we have relied upon. Jashoda Stores, Durga Rani Kundu, then 27, Lord, certificate of enlistment is there, Lord. Jashoda Stores, Durga Rani Kundu, she was the original tenant. And subsequently, after her death, Lord, it was transferred to the name of the present, that your lordship will find at page, Lord.
This is report.
Jashoda Stores. And Lord, the rent receipt that has been granted at page 37, from there also your lordship will find that this is a go down, Lord. Yes, Lord. So this is not a residential premises.
Lordship, my lord, in deciding an order 7, rule 11, my lord will see the averments made in the plate. Will consider the whatever stated in the plaint. What is the case? What I have stated in the plaintiff. Plaintiff claims himself to be the owner of the property. She averts that she has let out the property to one Durga Rani Kundu. The who was the original tenant. Original tenant expired in 2015. 2015. After she died, her son was in occupation and possession. Thereafter, in 2019, her husband, the son of the original tenant, has also died. Now the daughter-in-law is in possession, and she avers that in view of Section 2G of the West Bengal Premises Tenancy Act, which applies both to residential as well as commercial properties, that now since the period of 5 years has expired from the death of the original tenant, the daughter-in-law of the original tenant does not have any right to occupy the suit property, so she is seeking a recovery of possession of the suit property. That's the only plain and simple case she is. Now your lordship will kindly take up his application, my lord, in Order 7, Rule 11, he has to show that the plaint is barred by, or it should be rejected on any of the grounds mentioned in Order 7, under the head of Order 7, Rule 11. None of the grounds have been mentioned over here. 2G, my lord. My lord will kindly consider 2G, my lord. So we'll kindly consider 2G. Tenant means any person prescribed by rules made under means any person by whom or on whose account or on whose behalf the rent of any premises is but for a special contract would be payable and includes any person continuing in possession after termination of his tenancy and in the event of death of the tenant also includes for a period not exceeding 5 years from the death of such tenant or from the date of coming into force of this act, whichever is later, his spouse, son, daughter, parent, and the widow of his predecessor who was ordinarily living with the tenant up to the death of the tenant as a member of his family and were dependent on him and who do not own or occupies any residential premises in respect of premises let out for non-residential purpose, his son, spouse, daughter, and parent who were ordinarily living with the tenant up to the death of his members as members of his family and were dependent on him, but shall not include any person against whom any decree or order of eviction has been made by a court of competent jurisdiction, provided that the time limit of 5 years shall not apply to the spouse of a tenant who was ordinarily living with the tenant up to his death as a member of his family and was dependent on him and who does not own or occupy any residential. Provided further that the son, daughter, parent of a widow of a predeceased son of a tenant who was ordinarily residing with the tenant in the said premises up to the date of death of the tenant as a member of his family and was dependent on him and who does not own or occupy any residential shall have a right of preference over tenancy in a fresh agreement in respect of such this provider shall apply mutual to the premises let out to non-residential premises. 2G encompasses both my lord residential as well as non-residential premises. It encompasses both situations. Now, my lord, the protection, my lord, which a spouse or certain classes of persons which will get protection under 2G to enjoy the property for 5 years is now well settled, my lord. I will give your lordship the reference of that. Is a 2019 SCC Supreme Court 1601. I don't have a printout, but I will give the printout. It's a para 26 where the Honorable Supreme Court has held that a spouse or those class of persons will in commercial tenancies will get a protection for 5 years. If at all. The 5 years has gone 2019 SCC Supreme Court 1601. Just my lord. Yes. Well, just whatever. Just my lord, will kindly come to para 11, my lord. My lord, kindly, I will just give the hand over the side.
Lord, may I humbly beseech for one prayer, Lord. In the meantime, Lord, my application is pending, Lord.
This is my application. With regard to Mallet, if your lordship remembers, Mallet, partition of the property, Mallet. Also not sealed. Report. Could be the report, Mallet. Report a copy now. আরেকটা copy আছে? Mallet, what I find from the report, Mallet, this is in compliance of your lordship's order of 26th September 2024. Debo? Mallet, today, Mallet, first of all, Mallet, the main hearing, Mallet, but the reply, Mallet, I need some more time to put in the reply, Mallet. It's my fault, Mallet. I've not been able to complete it. That's my fault.
এটা ঠিক করে রিপোর্ট কার কত ভাগ সেটাই লেখে নিতে না ম্যানি
Right, but there are many tenants who are not my tenants in commercial. So Shekhar,
My lord, according to me, my lord, your lordship was directed that the corporation should make a division of the residential liability. It is there. So, my lord, I thought that whoever has what requirements has to pay it. Whoever is in commercial liability will pay their commercial, and whoever in
yes, one of the ground floor is entirely commercial. It's mine, but defendant number 2, my lord, has 5 tenants who are using it commercially. So defendant number 2, I suppose, my lord, appeared on the last occasion.
Let them divide it between themselves.
No, but that needs to be reflected in the report, my lord. I don't know.
Cannot be.
I do not know, my lord, how much to pay in respect of my share. That has to be, my lord, ascertained by the KMC itself.
No, my lord, if it's a tenant, my lord, with humility, I say, my lord.
I'll have to approach the KMC. I'll have to, my lord, file. Yes,
Same, what is your portion? What is their portion?
Yes.
What I will.
Yes. Absolutely, my lord. Yes.
And accordingly, they will
Yes,
also
my lord.
make payment of this.
Yes. Mr.
But I'm ready to pay.
I have one residential, my lord, on the top floor, and ground floor, my lord, I have. And I think 2 tenants, my lord, were under my they were my tenants. Defendant number 2 has 5 tenants, which are commercial spaces, my lord. So that needs to be, my lord, broken down accordingly.
Let us all file our comments on this report and what is supposed to be paid by each of us. And then, my lord, we can come before the lordship, and my lord will kindly direct that. এই রিপোর্টে তুমি কে কতটা পেমেন্ট করা সেটা করে
এরিয়া ওয়াইজ দিয়ে দিচ্ছি কোথায় আছি এরিয়া ওয়াইজ দিয়ে দিচ্ছি each one of us yes one
control code exception.
আরে দিনে অর্ডারটা দাও না একবার
I'm for the pollution control code.
No, my lord. Exception নেবে না তাহলে আমাদের শেয়ার গুলো বলে দেবে কেন আমাদের শেয়ার গুলো বলে দেবো সাপ্লিমেন্টারিতে কি আছে অ্যাকর্ডিংলি the court will direct the KMC to a certain action. Best
The parties to decide directed files their report. By clarifying that how much portion the parties are occupying, whether they are occupying.
commercial, yes, absolutely. Which duration we are in occupation?
First week of January.
The other way.
And I'll also extend my time for the reply and the exception.
Exception what?
Reply? No, to the pollution control code. And my extension of time to file my reply to the opposition also. Reply to the opposition. Huh? Very grateful.
Grateful. You know,
So item 15 and 15, I appear on behalf of the plaintiff.
I'm appealing
So
for the
there-
defendant, my lord.
Yes, Your Lordship. There's an application for rejection of plaint by my Lordship. Plaint. Lordship, they have Lordship filed by the defendant. Yes, Your Lordship. My injunction application affidavits are complete since there was an demurrer application.
Yes, my lord. That matter, my lord, on last. Yes, I have gone through, my lord. I have come up with a supplementary affidavit. I have served them yesterday. My lord, last occasion it has fallen from your lordship. It has rightly fallen from your lordship that one loan will not do. They have to give more than one loan. So I am filing a supplementary affidavit. I have already served a copy to my learned friend. My lord, we have found out that this company, Seema Tradecom Private Limited, has filed in 2019. They have filed another suit seeking recovery of money lent and advance. My lord, I have already.
Lordship.
Yes, I have.
Grateful.
Yes, and for production
I
of
want to
that
disclose-
claims, my lord, I have already taken steps, my lord, that is lying with
I'll
the,
disclose it in my opposition. I'll disclose the plaintiff.
my lord, in the main GA, my lord, they have not filed any opposition. So I,
Lordship, I'm not willing to file any because it's
Very
on
well.
order 7 rule 11. Your Lordship, I only need the plaint.
yes,
I only need to deal with the supplementary affidavit.
Very
Your
well.
Lordship.
dishonorable court, my lord. This court, honorable. My lord, it is, yes, my lord. Yes.
Lordship, 2 weeks. Lordship.
And may I file a reply against that one?
Grateful, Lordship.
My lord, can it be 24th or any date, my lord? 23rd January, any event would be a holiday, my lord. Yes. My lord, in the next matter also, I'm filing a supplementary
order.
affidavit, similar order. Grateful, lordship.
Grateful, Lordship.
Okay.
The 16, my lord, I am for the petition, my lord, the
Millard,
defendant, my lord.
I have
Defendant number 1, I have
Millard,
filed
I have Millard one application for amendment.
due to pendency of a proceeding.
He is appearing online.
Millard, Millard, pass over for 2 minutes, Millard. I am at the Walker letter, Millard. Just coming, Millard. 2 minutes, Millard, I'm coming. 2 minutes, Millard.
Yes. Yes. My lord, there are 2 applications pending before your lordship today. My lord, GA number 2 and GA number 3. GA 2 is the amendment application on behalf of the plaintiff. They want to insert certain facts. My lord, GA number 3 is my application because since I could not file my written statement because of the pendency of the probate proceeding in respect of the self-same property, which is the subject matter of the present suit, partition suit. My probate proceeding is going on. My lord's my lord, the service has been, my lord, it has been tried to be effected. My lord, they also aware of it. My lord, the probate proceeding kagozta daw. My lord, here is the suit for partition. My lord, here there are 2 it is involved in the probate proceedings. My lord, please.
Application was disposed of by your lordship, my lord, directing status quo of the property.
Yes, my lord. That is, my lord, the probate proceedings, the copy of the probate proceedings, my lord, may I hand over along with the will, which will, my lord, depict that the property involved in this particular suit is also a part of the probate proceeding and as well as the will. My lord, so far as property in the present suit are of 2 folds. Well, firstly, the residential property in its entirety is a part of the probate proceeding, subject matter of the will. So far as the other property is a shop business. There are 2 businesses. On the injunction application, I demonstrated that initially it was the proper business of the father. Subsequently, the defendant number 1, my client, entered into as a partner. My father died. father of the entire parties died. Thereafter, mother inducted. Subsequently, mother retired, and it is the sole proprietorship business of the defendant number 1. So there are 2 properties involved in the present suit, and in the probate proceeding, only in respect of the residential property. My lord, there are catena of judgments, my lord, which says, my lord, initially I got a judgment of Odisha High Court, which says that the partition suit should be stayed. My lord, there is a judgment of the Supreme Court also. My lord, there, my lord, it's a skeleton judgment without going into the details of the properties, the issues involved. My lord, there are the judgment of our division bench High Court. I will be relying upon one by one. I will placing. My lord, there is a division bench of our High Court which says that the preliminary decree, my lord, it has set aside the preliminary decree and directed both the matters to be heard out together, simultaneously. My lord, probate court before the civil court.
My lord, what has fallen from him? My lord, I am agreeable. No, my lord, I am agreeable. My lord, hear out both the matters together. Let it be
on
transferred.
last occasion, my lord, while disposing of the injunction application, it was fallen from your lordship that it can be brought together and the matter can be heard out.
Because my lord, the original set rules give my lord the power to get it transferred. No point my lord keeping it there. My lord will kindly my lord pass an order. My lord getting it because it's as a very nascent stage. My lord service is not yet complete. That and my lord it yes. No, my lord,
citation have been issued.
Citations have been issued. My lord, I will get a special citation anyway. Now, my lord, it's a I have not received any notice, no citation. Now, my lord, only my lord, it has been registered after we have served my lord, first interim order. My lord, recollect. Now, my lord, it had fallen from my lordship, and my lord, we concede, my lord, I accept that. My lord, kindly, my lord, because the injunction order is till the state, my lord, till the disposal of the suit now. No more it's my lord, day to day. My lord, my lord, pass an order. They have also said that it can be tried together. My lord, bring the probate case before your lordship's court. Any of my lord has a jurisdiction.
It is not my submission that it will be tied together. I have placed the position of the law as on today. It is your lordship to decide.
And my lord, be that as it may, my lord, when my lord, an amendment application has been filed, that to prior in point of time, my lord, the amendment has to be heard first. My lord, I rely on my lord, our High Court, Supreme Court. This is heard before my lord taking up any other application. There and my lord, there my lord, stay application. So my lord, I take it as order 7 rule 11. Yes. Yes. I accept that.
At that point of time, they can always place for the amendment application.
Yes.
That is there.
My lord will get it transferred, my lord. Yes, audience said rules give
I place the judgments, my lord, because the facts are, my lord, almost same. My lord, these are the the division bench is subsequently, my lord, I have made a total compilation. My lord, kindly take one by one. I am placing it. From the back, my lord, kindly see it is in respect of, my lord, period regarding the period of limitation that the property vests with the testator, that is in respect of 211 and 213, and is, my lord, the position of law. The difference between 211 and 213. Here is not the dispute. So last 2 judgments, my lord, may skip. That is, my lord, year 2001 Calcutta 122, and my lord, last 2 judgments of the compendium, my lord.
2120.
And thereafter, my lord, 2009 volume 10 SCC 223. These are the last 2 judgments. My lord, first one is that is, my lord, the last one. Yes, my lord. And thereafter, the second last is the 2009 10 SCC, my lord, 223. My lord, that is the 2005 12 SCC. My lord, it is from the back, my lord. 2018 volume 2 CLJ. My lord, this is, my lord, where, my lord, this honorable court held that even the mutation can be granted in the name of the executor. But this is not the issue here. So the position of the law so far as the executor is concerned, that is why I have taken the entire set. But thereafter, from the back, my lord, you will find the 2009-10 SCC 223. This is the judgment of the Supreme Court, my lord. Here, my lord, the position of law has been, my lord, in paragraph 53, 55, 57, 58. 2009, volume 10 SCC 223. I ought to have put the flag, my lord. It is, I take, my lord, it's my fault, my lord. My lord, forgive me, my lord. Yes, my lord. It's paragraph 53, 55, 57, and 58. This is also in respect of 53, 55, 57, and 58. This is in respect of, my lord, 211 and 203, the position of law. My lord, thereafter, my lord, before that, it is 2005-12 SCC. Here, my lord, the Supreme Court directed that both the matters to be heard analogously. Here, my lord, the Honorable Supreme Court in Nirmala case, which has been cited in plethora of judgments, that this Supreme Court in this particular is a one-page judgment, my lord. 2005-12 SCC, my lord. Right. Just before that, 2009-10 SCC.
Page 12,
505.
505.
2005, volume 12, Supreme Court cases, my lord. 505. But this is a one-page judgment where the Supreme Court did not enter into the controversy, but came into the conclusion that both the matters to be tried together. So this cannot be the, my lord, the position of law. My lord, let me place the other judgment, which will hold, my lord, the water. Yes. My lord, make it an order of court, my lord. What is my submission?
Yes.
My lord, make it an order of court. Because the judgment which holds the water, my lord, considering the entire judgment, is the first judgment of the compendium. 2024 3 ICC 343 and the subsequent judgment of our division bench 2016 volume 1 CHN Calcutta 302. 16 volume 1 Calcutta High Court notes Calcutta 302. This is the division bench of the of our High Court where the preliminary decree was passed, preliminary decree was set aside, and my lord, the matter was directed that both the matters to be tried together. But it is, being a counsel, it is my duty to place the entire position of law as on date. Though my lord is all aware of it, but it is my duty to point it out. But paragraph 15, my lord, kindly see paragraph 12 and paragraph 15. Paragraph 12, it has been, my lord, stated that the learned trial court ought not to have passed the preliminary decree, and paragraph 15, my lord, to be heard simultaneously. And the first one is the, my lord, considering the entire aspect, my lord, here, my lord, 2024 3 ICC. It's a single bench judgment. So, Formula Vishwas, yes. So this is the position of law as on date. My lord is well aware of it. My lord, 2024, my lord. Yes, yes, my lord. Paragraph 36, my lord. But that's all, my lord. So that is my humble submission, my lord. I leave it to your lordship. My lord, this is the position of law. I leave it to your lordship. My lord, may I place the probate the will once? The other property means only the. My lord, kindly see. My lord has got a copy of the. My lord, I have just handed over and given a copy to the my learned friend also. But the last page of that bunch, that is the last page of the will. Murder has got it. I am the absolute owner, internal page 3 of the will. I am the absolute owner of the entire land with buildings situated at municipal premises 26A Mahendra Shimani Street, Police Station, Yama Street, such and such. It is my wish that such and such. So this is the property was also involved. So the any decree passed in the this partition suit that may cause prejudice to the probate proceeding. So it should be heard out if it is not stayed. I leave it to your lords. And only another thing is that so far as this particular suit is concerned, my lord, I could not file my written statement, but within 120 days, I filed this particular application directing so that I can be restrained from, my lord will give me liberty to file written statement
That
within 15
he
days.
has to take out an application, you have a right
But
to oppose.
I have, my
He
prayer
cannot
is
take
there.
both
No,
ways.
no, my lord, I have prayed, my lord, kindly say it, because my right will go. My lord will appreciate,
Yes,
because
wait.
my lord's judgment is always there. I am aware of it. My lord, kindly see, my lord, the prayer, my lord, my prayer once. This particular my application. My lord, GA3, my lord. GA3. Because I'll be out of court, my lord.
Both the prayers are contrary to each other. How can it can come under one application?
No, my lord.
If
it cannot be.
otherwise it would have
It is
been
for
in
the-
any
for the
trial
ends
court,
of justice,
it
my
would
lord,
have been
kindly-
part under civil rules
my
and
lord,
orders.
let us submit one by one. My paragraph A is the stay. My written statement, my lord, give me 7 days time, I'll be filing. Well, just give me 7 days time. Only 7 days time. For the sake of justice, it is within 120 days this application is filed, my lord. Taken out. Prayer B, my lord. Give me 7 days time, I'll be, my lord.
Millet kindly takes Millet 2009 10 SCC 223 kindly comes to paragraph 8. I am shocked, Millet, these judgments are being shown. Kindly see this paragraph 8. Probate was granted. Suit was subsequent.
This was for the proposition I have submitted 211 and 213. No, 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 no.
You have not shown it.
Let us clear it.
No, no, এখন
It
clear
is for
করুন,
the
আমি clear
proposition of
করে দিচ্ছি।
211 and 213.
I am here. I am competent enough to clear it up. You have not shown paragraph 8. So Millet probate was granted in that matter. In this case, Millet, he has only filed. That too, even Millet subsequently to this. Millet, if he is Millet, I am not going into this. I am not pressing those judgments. Millet, I am bringing, carrying all those things that amendment should be heard and disposed of prior, even if order 7 rule 11 is pending. Millet, if he is agreeable, kindly make it an order of court. Let that be transferred. I will hear it together. Then Millet, I will press my amendment.
Give me just 7 days time to file.
And Millet, to that I am objecting because Millet, why? Millet, I have a right. Millet, kindly don't take me. Millet, because both the prayers, I am sitting. Only Millet, give me 2 seconds. Both the prayers are contradictory to each other in GA3. In one case, he is saying seeking.
One, my lord.
ঠিক আছে। It was granted. Suit হচ্ছে তার 10 বছর ওয়ারেন্টি। কেন? একটা প্রশ্ন আছে শান্তি মেলে হ্যাঁ
অন করে যাচ্ছে সমানে এবারে হতো না খুলে নিয়েছিস তো ওটা সিভিল কোর্ট মানে চিফ জাজ চিফ জাজ ঠিক আছে করুক না আমি পাসওয়ার্ড চাই আচ্ছা
Testamentary suit হবে না? Testamentary suit. TS ওটা ইউএস হয়ে যাবে, হ্যাঁ। এক্সট্রাঅর্ডিনারি সুট। আচ্ছা,
Yes, one. It's the job of the department.
Don't the dependent
Milad, only one prayer. I have Milad another application GA2.
No, well, that is could not be. That was for the first time. Opposition, 2 weeks after vacation, give us. But 2 weeks after vacation, 2 weeks after reopening, but because with this time after winter vacation,
21st of Jan. 22nd. 22nd.
But I'm flip place.
আচ্ছা Milad, Mr. Mitra will not be there from that week. Can it be on 29th? Give me 2 weeks, Milad, then I will utilize that time. 25th of February. Monthly list na to? 5th of February?
I'm grateful.
Wait. Obliged.
There are two issues. The original issue in the application for setting aside of the ex-parte decree. Order 9, Rule 13. Now, if your lordship kindly have a glance to the where in the application. And your lordship also kindly see the two dates. First, your lordship was pleased to pass the judgment and decree on March 24, 2023. And the application has been filed on 2nd April 2024, after 1 year. Now, in this application, if your lordship kindly see the notice of motion, the notice of motion is only in respect of setting aside of the judgment and decree. Now, in the application, they have raised an issue. This is, yes, page 9. Your lordship can take from page 8, paragraph 13. It is stated that said degree passed without jurisdiction and the procedure conduct in obtaining the said degree is improper. Moreover, the said degree is a nullity and non-est. The said degree is liable to be set aside on the grounds stated herein above, as well as the following reasons. The CS 220 of 219 has been filed as a non-commercial suit in the ordinary original civil jurisdiction of this honorable court. It appears from the said decree that the dispute alleged CH 220 of 219 arises out of a work order for construction of a building for setting out of a leather factory over a land allotted to the defendant at Kolkata Leather Complex. The said decree records the submission of the plaintiffs that on June 24, 2014, a work order was issued and the plaintiff undertook the construction work and completed the entire work without any objection from the defendant. The said decree further records that the submission of the plaintiff that the dispute arose after final bill was raised by the plaintiff but not paid by the defendant qua petitioner. The plaintiff qua respondent has raised demands through several correspondents. However, the defendant did not pay the outstanding as alleged. Consequently, the plaintiff has constituted to institute CS 220 of 219 against the defendant for recovery of money together with the interest thereupon. It is pertinent to mention the dispute complained of was clearly a commercial dispute. Pausing here for a moment. Now, they have given two things. One, work order for construction. If your lordship kindly take up the commercial act, commercial court acts. The definition. To see, commercial dispute means a dispute arising out of. So, the word dispute is most important word. What dispute to be arose? This is ordinary transaction of merchants and bankers, financiers and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. This is not export-import, no. Issues relating to admiralty, no. Transaction relating to aircraft engines, no. Carriage of goods, no. Construction, infrastructure contracts, including tenders. If it is come, where is the dispute? May I put this question to myself? They have issued work order in my favor. I have started construction. They did not say this construction is faulty. This construction cannot be done. This construction cannot survive. They did not say construction work over. Part payment made. When the final bill raised, they say don't put the final bill now. We have now in financial constraints. Put after some time. We waited for 2 months. Then we placed the final bill. They did not raise any objection. Even they did not answer at all. Now, had it been any dispute in respect of my bill, maybe that we have work order is of 20 lakhs, we have already paid you 15 lakhs, another 5 lakhs you can get. You have raised a bill of 10 lakhs. You cannot get it. They did not. Even if they say in this petition, this is a commercial dispute we have raised, that cannot substantiate their claim because they did not raise any dispute during the prior to filing of the proceedings. Now, demand is of mine. But now, if there is any demand and if any dispute raised on that is a dispute as per the Black's law. Your lordship kindly see. That I have also checked it. Oh, sorry. This is my mark. Your lordship kindly pardon me. First of all, for reading purpose, I have marked it. Then I have xeroxed it. This is from Black. Dispute. A conflict or controversy. A conflict or claim or rights. An assertion of a right. Claim or demand on one side. Made by contrary claims or allegation on other. Nothing. The subject of litigation. The matter for which a suit is brought upon which issue is joined. So, if there is claim and counterclaim or dispute or objection, then the suit brought then that is a dispute and that can come. Here, nothing. This is one-sided, totally one-sided. I raise the demand. Your Lordship kindly appreciate one thing. I raise the demand, no doubt. No answer. With this bill, part payment of the bill, part payment of the bill. Now, but there is no dispute regarding commercial work. In the suit, and if they raise the dispute, your Lordship may shift. Now, there is why I am saying there is some degree of difference. But this is one dispute. There is no, according to me, there is no dispute. Secondly, your Lordship can see chamber. Here also, dispute. Yes, your Lordship kindly see left hand side, last dispute. To question or deny the accuracy or validity of a statement. No. Your Lordship, this is specific. To question or deny the accuracy or validity of a statement. To quarrel over right or to possession of something or dispute territory. To argue about something. It is more specific. The first sentence is the question or deny the accuracy or validity of a statement. My demand is a statement. No question relating accuracy or validity of the demand. So it is not a dispute. Someone, if there, now your Lordship kindly see the definition. If there is no dispute, can it be a commercial dispute? Commercial court can take. এক মিনিট আমি বলিনি আমার মধ্যে তারপর কিছু মিস হলে তখন বলি না মানে what the commercial court will hear a commercial dispute. What is a commercial dispute? A dispute arising out of. Now here the specific to question or deny the accuracy or validity of a statement. No deny, no dispute. It is one-sided. Absolutely one-sided. Now, but even if I accept my learned friend's contention is absolutely correct, that this is a commercial dispute. A decree has been passed by this court inadvertently or mistake, or my client has made this abuse of the process of the court. Even if I go to that extent, can this court, may I put this question to myself, can this court in an application in Order 9, Rule 13, exercise that inherent jurisdiction? Simple answer is no. Because there are other remedies as per the code. And there is a consistent view of our High Court as well as other High Courts of India. Yes, Supreme Court and also our High Court. Our High Court, the decision is, your Lordship kindly gives 1 minute. I am handing over the decision. এটা এটা সরফেরটা দাঁড়া দাঁড়া আমার দাগ দেওয়া আছে ওটা নিলে তো হবে না এটাই নেই দাঁড়াও দাঁড়াও বার করছি মাই কপি বলে পেছনে লেখা আছে দেখো আছে Yes, এটা আমার জজ সাহেবের সারাফের কপি একটা দিত কোথায় গেল গুম আচ্ছা এইটা দিন ওইটা দিন এটা কপি গেল ওইটা একটা করে কপি তো দিয়েছি একটা কপি একটা করে কপি তো করে দিয়েছি এটার একটা কপি 2008-এ নাও ইউর লর্ডশিপ কাইন্ডলি সি দিস ইজ দি জাজমেন্ট ডেলিভার্ড in reported in AIR 2021 not AIR 2021 1 Calcutta Law Times 217 and 2021 SCC Online Calcutta 34 no 2021 volume 1 CLT 217 ঠিক আছে আচ্ছা this is MR Mining and Construction Private Limited that is Manju Habar. Now your lordship kindly come to the fact of the case that the Honorable Court has been pleased to pass an order. This application has been filed for setting aside of the degree. Same thing, Order 9, Rule 13. Now your lordship kindly come to page, paragraph, yes, paragraph 9. On the other hand, section 151 CPC saves the inherent power of the court which provides as follows. This is inherent power 151. Paragraph 10. As evident from a bare reading of the provisions of law extracted above, the grounds of fraud and or abuse of the process of the court. Grounds of fraud is not present, abuse of the process, if I take it, abuse of process of the court are not conditions which would merit the court's interference, especially under Order 9, Rule 13. Rather, Order 9, Rule 13 stricto sensu envisage two particular conditions, either of which is if fulfilled warrants an interference by the court to set aside an ex parte degree. These conditions are either the defendant satisfies this court that the summons were not duly served upon him, the defendant was preventing by any sufficient cause from appearing when the suit was called for hearing. Nothing can be proved, nothing was proved, and practically Mr. Dotto, my learned senior friend, has practically waived this. He said this is not. He only harp on the commercial dispute. Now, the only issue remaining this. Then, the applicant defendant had not pressed either of these conditions before this court, just like this. The predominant plea that has been of fraud and or abuse of the process of the court. Therefore, the natural progression would be to examine if the grounds of fraud or abuse of process of the court are not covered under Order 9, Rule 13. Would it be statutorily permissible for the court to rely on Section 151 and invokes its inherent power to provide relief to the applicant defendant and set aside an ex parte degree that may have been so obtained by either resorting to fraud and or abuse of the process of the court. Next, the Supreme Court in Ram Prakash Agarwal versus Gopi Kishan reported in 2013-11 SCC 296 held as, in an exceptional circumstances, this court may exercise its inherent power apart from Order 9 to set aside an ex parte degree. An ex parte degree passed due to non-appearance of the counsel of a party owing to the fact that the party was not at fault can be set aside in an appeal preferred against him. So is the case where the absence of a defendant is caused on account of mistake of the court. An application under Section 151 CPC will be maintainable in the event an ex parte order has been obtained by fraud upon the court or by collusion. The provisions of Order 9 CPC may not be attracted. In such a case, the court may either restore the case or set aside the ex parte degree in exercise of his inherent power. there may be an order of dismissal of the suit for default for appearance of the plaintiff who were in fact dead at the time of the order was passed. Thus, where a court employs a procedure to do something that it never intends to do, there is miscarriage of justice or an abuse of process of court. The justice so done must be remedied in accordance with the principles of aqua curis nemin debit. An act of the court shall prejudice no person. In view of the above, the law on this issue stands crystallized to that effect that the inherent power enshrined under section 151 CPC can be exercised only where no remedy has been provided for any other provisions of the CPC. In the event that a party has obtained a decree or order by playing fraud upon the court, or where the order has been passed by a mistake of the court may justify in rectifying such mistake either by recalling the said order or by passing any appropriate order. However, inherent power cannot be used in conflict of any other existing provision, or in any case a remedy has been provided or by other provisions provided for by any other provisions of the CPC. Moreover, in the event a fraud has been played upon the party, the same may not be exercised where inherent power is not required. Therefore, this court does possess the power to invoke the inherent power under section 151 CPC to provide relief to the application defendant in such a case where fraud or abuse of the process of the court may transpire. However, where the applicant defendant has successfully discharged his burden, proving the same containing the nature of payment, it's not required. Number 8, here, now your lordship kindly come to paragraph 17 of this judgment. 17, 18, 19, and 20. And 21. Upon an application of my mind, as well as yardstick laid down by A.C. Anantasamy, the new factum has referred to in the immediately preceding paragraph does not appear to me a case of fraud or abuse of the process of the court. The decree providing fraud is much higher, an ambiguous question of fact itself. Moving forward, for the options to disposal of the application of the defendant to set aside ex parte degree, March 13, the applicant defendant could have either filed an application on order signed Rule 13 CPC, whereupon if an application is dismissed, an order is dismissed would be applicable under Order 43 Rule 1D, or filed an appeal under Clause 2 of Section 96 CPC. The nature and scope of both the remedies need to be retained. Reiterated by Dr. D.Y. Chandrachud J. speaking for 3 other judges in the bench of Supreme Court in Nidja Retailers Limited versus Jaggu, through legal representative 2018 to SCC 649 has enunciated the procedural scope of both the remedies in the following terms. A defendant against whom an ex parte degree passed has 2 options: that he has to file the first has to file an appeal, second to file an application under Order 9, Rule 13. Defendant can take recourse to both proceedings simultaneously. The right of appeal is not taken away by filing an application under Order 9, Rule 13. But if the appeal is dismissed, as a result of which ex parte degree marches with the order of the appellate court, a petition under Order 9, Rule 13 would be maintainable. When an application under Order 9, Rule 13 is dismissed, the remedy of the defendant is under Order 43, Rule 1. However, once such appeal is dismissed, the same contention cannot be raised in a first appeal under Section 96. The 3 judges bench decision, Bhanu Kumar Jain, has been followed by another bench of 3 judges, Ravindra Singh versus Financial Commissioner Corporation, Punjab, and by 2 other benches, Mahesh Jadhav versus Rajesh Singh. In this present case, the original defendant chose remedy of the first appeal under Section 96 and was able to establish before the High Court adequate grounds for setting aside the judgment and degree. However, a subsequent another 10 minutes. I know, my lord, but I am getting both the occasion at 12:20, 12:25. What can be done? If your lordship is so busy, I can come next Thursday, next Wednesday. 16 year lordship can give one. Yes, yes. No problem. Rest of the judgment I shall read on that date. তোর অসুবিধা নেই তো? হ্যাঁ হ্যাঁ ও ঠিক আছে, আমার জানি হোক আমি চলে। হ্যাঁ ওটা জজ সাহেবকে তখন দেবো। বইটা কোথায় গেল?
This is my turn, the next matter. But is there any possibility of it being taken up after lunch?
2 p.m., 3 p.m., 3:45 p.m.
Because I was planning to leave, but if it's going to be called, then I'll stay on. But I was going to go on holiday. I mean, leave. Next matter, 18. Next one.
The next matter which we mentioned for return notes.
I believe there's no chance after lunch, but in case the list is called on, I'll come and do it tomorrow or whenever it suits you. And I'll take 15 minutes, so 15 minutes is what I'll take.
My lord, I appear for the plaintiff in this matter. As per the last order, direction for inspection and disclosure were given, my lord. We have disclosed, both parties have disclosed, and inspection has been completed. My lord, the judge's brief of documents is to be prepared, my lord. Kindly grants us, my lord. My lord. Yes, it's a contested matter, my lord. Kindly see, my lord, last order dated 10th May 2024. Yes, ma'am. Yes, my lord. My lord, so title suit number 10 of 2024. The judge's brief has, yes, my lord.
Lordship, this is my affidavit of admission denied on behalf of the defendant.
This is that has to be prepared, my lord. Kindly grants me a fortnight's time. Thereafter, my lord, issues have to be framed. And my lord, in the meantime, we are taking out an amendment application. There are certain typographical errors, my lord. Two weeks time for documents.
2 weeks. 2 weeks, my lord. 1 week after the vacation, my lord.
Issues or amendment application. They have not disclosed in document.
May it please, my lord, I appear for the executor in this matter. Yes, my lord. I don't know why it's appearing. It's wrongly. Extremely grateful, my lord.
Number 32. 32, my lord. We appear for the caveators that matters parted before your lordship, that matter. Mr. Meghna, yes, from the earlier determination is going on that Mr. Meghna Datta was arguing for we have taken the point of the forged will. I have concluded my arguments. Yes, his argument is going on. That should be a fixer. That is the thing. Mr. Datta was the minister of the argument. I think. Yes, I'm for the defendant. This was advocate on record of Mr. Datta. লালদা আছে দেখ না ভাই, লালদা কি এখানে ছিল? হ্যাঁ, লালদা আছে কিনা এটাকে না পাল্টাতে হবে, অত কিছু দেখতে হয়, চিপকে দেবো একটা কিছু লাগাচ্ছে। Yes, we can fix a date. That will be better. Fix and time. Lordship's pleasure was to be finally written.
345, I recall. 14 January. Oblige me. 14 January.
Item 33. This is my probate application. There are two GA file. One is GA1 and GA2. GA2, your lordship, has already been disposed of, and GA1, your lordship, the affidavits have already been completed. Yes, your lordship. They file a application for dismissal of my probate application, only alleging, your lordship, that I have actually not included the name as the heir of your lordship, the deceased. And on that basis, they also filed a 340 application, your lordship, and prayers have been included. If they want to file, your lordship, they think that they have a caveatable interest, your lordship, they can always apply for your lordship the lodging of the caveat and filing of the affidavit in support of caveat. But they want, your lordship, my probate application to go and multiple prayers regarding, your lordship, the 340 and that why I have not given, I have made false statement. This is the entire scope, your lordship, of this application. If they want to file, let them file, your lordship, evidence in support of caveat. I will not.
My lord, I'll tell you what the issue is, my lordship. They have said that they have tried to approach the surviving legal heirs, where they have not given consent. But the problem is, my lord, they have mentioned the legal heirs, 3 of them have already died, my lord. So there is a misleading statement. Kindly, my lord, takes up. Yes, my lord. Paragraph 7, yes, my lord. Yes, my lord. Page 4, my lord. Page 3, my lord. Yes, my lord. This Prashanto Kumar Gupta, my lord, he has died, my lord, on 12th of my application. Main probate application, PLA application. He has died on 12th of December 2008. Then, my lord, Shefali Roy is my client, my lord. She has filed the caveat and also the affidavit in support of the caveat. And, my lord, third, my lord, she had died, my lord, on 8th of December 2005. The executive is not related, my lord. Not related, my lord. Outsider, my lord. Absolutely rank outsider, my lord. She, she was the caregiver, my lord, and GA1, my lord. I am bringing for dismissal because the deceased person, my lord, one of the brothers, my lord, Ashok Gupta, my lord, he has not been included, my lord.
No problem. Prashanto, he is saying Prashanto is dead. Nivedita is Mojumdar is dead. Shefali has already filed, your lordship, affidavit in support of caveat. I will make the necessary amendments, and I have till date, your lordship, I have not filed because they filed a 340 against me and your lordship dismissal. I will file, your lordship. I don't have any. I will include him. Lordship, I will file, your lordship, necessary application. Let him file, your lordship, the affidavit in support of caveat, and your lordship, it will be decided. No, they have not filed.
Gupta has not filed, my lord. One of the brothers, my lord, has not.
They have not.
No, Shefali has been filed. Shefali has filed. Ashok Gupta has not been made a party, my lord. So he doesn't. This is another legal heir, my lord. He has been excluded. He is the brother of the deceased.
So I am not standing on the way. If they want to file, your lordship, affidavit in support of caveat, let them file it, and I will make necessary amendments, and the suit will proceed.
My lord, I can agree, my lord, if they file it afresh, my lord. So what they have not paid the 50,000 rupees court fee, my lord. And paragraphs 8 is also misleading, my lord. But if they amend, my lord, then
I'll file necessary amendment application. Let him file the affidavit in support of caveat. I mean, no problem. I'll file your lordship. 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 Proceedings. Lordship. I'll file your lordship the amendment application as early as possible.
my lord, one caveatrix and one brother, my lord. 12/12/2008, my lord. 2000, Prashant Kumar Gupta.
No, it's a combined
Same
application.
combined
Combined
application. Combined applications. Testator.
Hanuman. Yes. I'll take steps, Lakshman. Amendment. खत्म करो इसको.
But I am for the application. In compliance with Lordship earlier direction, my lord, on 14th of November, my lord, I have once again served copy and intimation upon both the banks, my lord. My lord, this time also, my lord, the PNB he refused to accept with the same endorsement, my lord, no such person in this address. My lord, this time, my lord, I have downloaded the photo and the address from the internet where I have got the address of the bank. The bank, my lord, both the bank, the Central Bank of Chetla branch and the Punjab National Bank Chetla branch. My lord, both the bank are in the same place, my lord.
Where you got the address? The address are correct.
Yes, yes.
So what is the report?
That no such person is.
Not such person. Speed post.
Yes.
So this is with regard to the Punjab National Bank. Another one. What about
Central Bank receipt.
receipt?
The locker is like central.
What about why the Punjab National Bank?
Because Punjab National Bank, my lord, some FD fixed deposits are there.
So why you want to enter? You disclose the affidavit of the search?
Yes. In the asset, where when in the affidavit of asset affirmed at that time, my lord, these fixed deposits and the information of locker, it was not included in the affidavit of assets. Which is a concept. That my prayer for inventory to the locker
Of the Central Bank.
Central.
So Central Bank has received.
Central Bank has.
Where is that report? Have you submitted here?
Yes, yes.
Which paragraph?
And it is the fast track report, madam.
Now, where is your government? Receive the documents from Central
The
Bank.
paragraph
Central Bank receive the documents from Yes, where is the affidavit of asset?
That's it. I found on 13th of August 2019.
Which floor? The locker, the locker number 47.
Now it is a new number.
What is the number?
I have mentioned in my GM. Kindly come to the prayer method at page 3. G1.
You have a copy of that?
Yes.
But you have not amended the number in the application, affidavit as certain, no?
Well, subsequently, I received the information.
Presently, locker number 77.
Well,
Locker number 47, presently locker number 77. Have you got
initially it was 47.
Yeah, right.
Well, now the locker number is 450212220. The bank has intimated that
Where is
information.
that letter?
Well, I have annexed with the application. With the letter, my bank intimated me.
New.
Yes.
Concession for that's 5 different steps. Here one of the playing for this allowing that petitioner what authorized representative allowing the petitioner open locker number 47 within the present within the new number new locker number 45021222022 located at Central Bank of India, Jeddah branch, Kolkata. Also, for the petition submitted at the time of filing of the prepared application around the affidavit surrenders, the petitioner the locker number was 57. Now, from the certificate issued by the bank, dated 10/12/2019, the petition came to know. But how, madam, this is the certificate of 2019. And you filed the affidavit.
Well, at that time, it was not the knowledge of it.
The petition has mentioned the locker number 47, but has not mentioned the new locker. Locker number 450. That's and what are the of the central bank of Jeddah or any of the of the state bank. Continuity of the articles available in the system. After the petition again of the state and by the process. Take action and will take up to the step of identity. Consider It is found that the petitioner has sent the notice to the Central Bank of India, Central Bank of India, Circular Branch, by speed to the served upon deadline, but considering the above branch manager of Circular Branch of Kolkata bracket south or any of the of India is directed to allow the businessman to open Dr. Nafa Food with package 4, 5, or purpose of taking inventory of the material and article design available in the section. If is after offering so manager or the relationship of the article or that makes the manager or the making the locker in lock and submit it also finds that the petitioner has sent a notice to the branch manager in the bank, Punjab National Bank, from a Chetla branch, having the office at 50/H/E capital A, from a Alpur Road, Bangla, from Alipur, Kolkata 27. But the postal authority has submitted the report, not such person in this sentence. Will be of the other. The petitioner South manager, branch manager, or the manager, or the competent of Punjab National Bank, Chetla branch, having a subset 50/H/E capital A, through the officer in charge of the of which is officer and the officer in charge is directed if the petition approaches the officer in charge for service services. For supply for service of Punjab and to file the report before the court of any articles found that first done, then I will whether bank that the police submit the report bank is available or because the report of the postal officer is not proper. And the I cannot call the report from the bank if bank is available or that's why the police officer submit the report. But in the article 9 proper it has been to value the articles. First make the inventory. If then thereafter. That's how it can. Let the matter appear. Let the matter appear on 30th of January. And if the petition directed communication forward to yes. Yeah, I know 35. Yes, my what is the issue? Another issue?
Filing this affidavit documents. Before that, we have got submit one document which we have found subsequently on it. That document you want to disclose it.
What is the document?
Document one property which is mentioned in the affidavit asset. That property has been sold out before the property is granted.
Before probate is under probate filing for filing of the probate application.
Sorry. Well, after filing of the probate. After filing of the
probate application, the property has been sold. Who has sold?
The wife of the deceased.
Wife of the she is not execute. She is not the
She is not executed. But
I am the younger sister. Younger sister of the deceased.
Deceased.
I am the youngest daughter of the deceased. Daughter of the deceased. Yes. Youngest daughter of the deceased. My youngest friend is my younger sister. Sorry, I'm sorry. Elder sister. It's a registered will. The testator is the father. Testator is father. You are one sister. He is one sister. And who is the sole executor? Who is the executive? I'm the executive. You are the executive. You have made a party to him. Yes. And now she has filed an application. She has got the caveat.
It has already been treated as
so whether the property which she is telling that is the part of the affidavit of asset?
Yes, my lord. Yes.
Where it is?
Affidavit of asset, my lord. If you will kindly have a look to the application and affidavit of asset.
Where is the affidavit of asset?
Which has been thought, my lord. If you will kindly come to the affidavit of asset, my lord, this is my lord.
Which property?
That is Metropolitan Cooperative Society. If it is internal page 5 of the affidavit of asset.
Last one.
Mal.
1/4 share of the P by 1/4 sector. A. Metropolitan Cooperative Society.
Flat.
Flat. So this was sold.
Mal. And we have already applied for the certified copy. We shall
you take steps.
Yes, madam. And all so far the application is concerned, we have to file application document.
Which one?
The application.
What application? No. Probate matter contested, no commission. It is in the court. With the probate court, this probate, this court will not allow commission. This was who is mother? Mother? Who is the test executrix here? So mother is old, no problem. But she's one of the attending. So you bring it. Bring it. Are you fixing a short date?
As you look, so for
Issue is concerned, no such.
Attending witness.
Attending witness.
Why there is no attesting
There
witness?
is attesting witness.
So why the attending witness?
My lord, the reason, my lord, now since it has been converted into a testament.
Correct.
My lord, they'll take all the efforts of, my lord, disproving the will. My lord,
Correct.
since she is the wife of the testator, my lord, and she was there at that time of the execution, my lord, there are several important issues which can
several important. First, you have to prove through the attesting witness not, or you want to give other attending witness, not attending witness, eyewitness, whatever it is, you can give that. But it is the what the law provides.
My lord, it's obviously section
Then
63 says attesting witness, my lord. My lord, but I was only on the urgency, so because she is very old. For this reason, my lord, I was only praying that the short date may be fixed. We can done.
She has come from USA.
Where is the issues?
Issues
My lord, I have filed my issues.
One judge's brief of document has not yet been prepared.
Who?
Prepared by.
Not filed.
Not, my lord, I have filed my suggested issues and the.
What about the judge's brief?
My lord, I'll file it then, my lord.
When?
And so far, the affidavit of denial and admission document, that is also not supplied.
That has been filed by me.
But that is not supplied to us.
Affidavit
is obviously supplied.
No, affidavit, admission and denial. May I be permitted to file my affidavit, suggested issue?
Where is the suggested issue, sir?
My lord, I have filed my suggested issues, my lord.
When? देखो इसमें है.
My lord, on November 28, 2024.
Suggest judicial copy.
Why your issue number 1, whether the application granting probate is now converted is maintainable or not? Why?
Because there are
This has caused it has been converted into testament. How you are raising the maintainability?
Not maintainable because there are certain defects.
What?
So that is one of the property which has already been sold out.
That is different thing.
Apart from that one, there are other. That is why you have said so.
Where is your affidavit of asset? Affidavit of
Yes, my lord.
caveat.
Caveat, my lord.
Affidavit in support of caveat. Where is that?
It is
If
fine.
affidavit is there? Only one.
Only one. Only one. Only one.
If the affidavit in support of master summon. Caveat. So it can be framed whether the testamentary suit is maintainable in its present form.
As you lost, I'm sorry.
Converting into then it will be
Yes, Malad, that is Malad. No, that is Malad. I'm sorry. That particular word is to be deleted.
So maintainability, okay, I will take. And with regard to the second,
Malad,
whether the executives or plaintiff is get to decrease, then he has given the suggested issues 4 number.
This.
4. Whether the plaintiff is entitled to grant probate of the will of son, that is covered. That is covered.
Malad, that
correct.
is covered.
So that I am not taking. Whether so-called will is executed tested.
And Malad, so what the 5, though it is a long 5 size.
I am coming.
I'm sorry.
So 3 and 4 is overlapping.
Malad, 3, 4.
3 I am taking,
Malad,
4 I am not taking.
Malad, 3, 4.
This is the cross-examination.
But that is as you love it. But this is a fact. He has admitted in his affidavit.
Put in cross-examination.
Malad.
Whether the testator was at all in the sound mind.
6, Malad. 6 is very essential.
Sound mind. Now kindly, then I will take.
See, suffering from cancer, Malad, certain medicine he was taking.
Okay, I will take.
That
is the main.
There in my suggested issue.
I am dealing with that. Because you are not taken with regard to the sound of mind, fit state of mind. You are not taken that, please. So he has taken the 6. So that remains because that is the main issue. So 7 also it is your defense.
Yes, that is also defense.
Because 7 will cover with regard to the 2 and 3 of this, because surrounded by suspicious circumstances or influence.
Yes,
so it will cover the.
Yes, I'm grateful. Those sizes are to be taken.
So the 8 is covered under 6.
Yes, 8 is
covered under 6.
Malad.
Undue influence. 9 is 3.
3.
9 is 3.
With the Malad. Yes. Malad.
Yes, 10 I will keep.
Yes, my lord.
10 I will keep.
My lord, I'm grateful to it. And this is not properly drafted. That is
and 11 covered under 2.
2.
2 and 3 both.
Malad,
influence and the surrounded by
Malad, yes. 12 and 13, Malad, that is
registered will
usual.
of testament is binding upon the caveatrix.
Yes, because Malad, some portion has been already sold before filing the application by one of the heirs of the deceased, and that is included in the affidavit asset. And apart from that, well, there are other reasons. That's why you are.
No, that so binding upon the deceased, if the court is granted, will grant the probate
In
automatically.
that case, well, I am binding, but before that,
Relief, then 13 I will take.
as well.
So opening for the plaintiff, so opening for the defendant. Both the parties have filed their suggested issues. After considering the submission made by the counsel for the parties, pleadings, and the suggested issues, the following issues are framed. 1, 2, 3, 4, 5, 6, 7, 8. The plaintiff has filed an application, what application? GF2?
G2 for
Filed an
appointment of an
application being
advocate.
GA2 of 2024. Praying for what?
Appointment of advocate commissioner.
Praying for appointment of commissioner for examination on commission of the attending witness. Attending witness. On the ground that the attending witness is old age person. Full stop. This court find that the suit after receipt of the affidavit in support of caveat, the probate application has been converted into contentious cause and it has been treated as testamentary suit and the defendant is contesting the suit. The plaintiff has to prove the case in accordance with law. And as per the will, there are two attesting witnesses. Without attesting witnesses. Now the plaintiff intend to examine the attending witness. Thus, this court did not find that at this stage the application can be allowed. Accordingly, this court feels that let this application be remain pending till the further till the examination of the other witnesses. Full stop. The plaintiff pressed for time to both the parties have filed their affidavit documents and you have filed the affidavit document.
Yes, we have filed.
Defendant has filed the affidavit document.
I
Let
want
the
to
same
file
be kept with the
additional.
record. Full stop. Counsel for the plaintiff pressed for time to file affidavit, file judge's brief of document. Let the same be filed within.
Within 1 week after the opening.
Within 1 week after winter vacation. Full stop. Please the matter on. Give the date for witness action. 6th of February at 2 p.m. for
And
witness
Mala
action.
liberty to file additional documents, Mala, to disclose the additional documents.
You file an application.
As well as.
My lord, I'm also filing my affidavit of service.
What?
Affidavit of service.
Affidavit of service filed by the plaintiff be kept with the record.
I shall file application for that additional document. Disclose.
Next.
Okay.
My lord, this matter I'm for the caveator, my lord. In a partition suit, my lord, this honorable court pass a certain direction, my lord. In connection with this matter also, may I hand over the copy of the orders, my lord? Their initial order is 3rd December and thereafter some changes, modification in 10th December, my lord.
My appeal, which is disposed of by the Honorable Division Bench, in the PLA, there's several observations which will relate to the suit. As a EMLO will recall, this is where a partition suit has been filed by my learned friend's client against my client and the other legal aids. And there's a connected PLA. There was rejection of plaintiff application which we had taken out. Malord had dismissed it, we'd gone up in appeal. In that context, the division bench has caused several observations with respect to the suit as well as the PLA. Now, what is relevant for today, Malord, in the PLA, they have been given time till 10 January 2025 to file their affidavit in support of caveat. I am not the executor.
My lord, I appear for the executor.
So, Malord, for the PLA, perhaps it has to be adjourned till after 10 January for them to file their for them to file their
affidavit
in support of caveat in this PLA.
So it is still it's not been come as a testamentary.
Not yet.
Not yet.
And where is the partition suit?
Partition suit.
Is the 2020. Malord will recall this is where we had filed an application.
Lordship has passed the order.
Before Malord only we had argued, saying that Malord the suit has to be rejected or stayed at the very least pending the disposal of the PLA. In that context, Malord had dismissed all our applications for stay and rejection of claim. we had preferred appeals against the three applications.
So what the appellate court say?
My lord, page 5, my lord. Kindly come to page 5 of the 3rd December order. Yes. 3rd paragraph, my lord. In view of the
The
4th
executor
paragraph.
is
my lord.
required to make a party in the partition suit
Next paragraph, evidence in support of the caveat.
as the representing estate of the deceased without prejudice to right and contention of the widow, an application should be filed implead the executor within 10 days. Affidavit in support of caveat shall be filed within by 10th January.
And another
affidavit of support in caveat here.
Here, my
And you have to file an application there in the suit.
in the suit.
In the
That
suit.
was filed, my lord. That was filed within time.
Shall be treated written statement. Affidavit and executor be impleaded. A copy of the amended print be the writ of summons shall be served upon this one so.
Another direction, my lord, page 3, my lord. Page 3, considering the aforesaid, we feel that the partition suit and the probate proceeding are required to be heard analogously.
Correct. That's why I wanted to see where is that order.
Page 3, my lord.
Page 3. That's why initially when I was hearing and you both are not ready. That's why you passed the judgment. Otherwise, the same order could have been
We had
passed.
an injunction application, my friend.
Without him, perhaps because he's been now impleaded in the
When that application was taken up a ring, the very first day I asked
yes,
whether you are ready, then I will call the suit. You both are not ready. So that's why I got the same order from the appellate court. So what do you want now?
My lord,
I am only a beneficiary here.
What is your contention?
My lord, the caveatrix, my lord, has to file that affidavit in support of that caveat, my lord.
You can miss this matter in the
My lord, after 10th of January, my lord.
So appearing for the you are for the petitioner.
My lord, for the executor, my lord.
Petitioner,
Yes,
you are for the
yes,
petitioner. So appearing for the petitioner, you are for the
one of the legal aids, but I'm not a party. I've consented to
so appearing for the caveatrix. Full stop. In terms of the order passed by the Honorable Division Bench in APOT 212 of 2023, dated 3rd December 2024, the caveatrix has required to file affidavit in support of caveat by 10th of January 2025. Thus, in view of the order passed by the Honorable Appellate Court, the case is adjourned. Let the matter appear on 30th January 2025.
My lord, one more indulgence. Page 3, my lord, both the proceeding will be heard together. So, and that is before the Honorable Justice Sugata Mujumdar. So,
2020, my lord, sir.
Which
2020.
So mention it, then on that day I will bring both the suit together and I will pass an order when this will come. Then I pass an order, both is to be in terms of the division bench order, both is to be heard together.
Grateful, my
Oh my lord.
Yes.
This is the next matter, Your Lordship. Formal order, one amendment. Had satisfied the court. I have an order of court.
Come.
My lord, one prayer. Instead of 30, any other day, my lord.
Why?
My lord, I have some personal difficulty on 35.
28? 29?
29. Grateful, Lord.
29 kar do.
Grateful, Lord.
Come tomorrow.
Final. Lord, to answer.
Yes.
So Lordship would recall, Lord, this is a suit for partition, where we had taken a point, Lord, that because all necessary parties, including the heirs of Lord Lord Ravindra Kumar Mehra has give me one. Ram Prasad Mehra. But all heirs of Ram Prasad Mehra have not been made party. Similar to that, the plaintiff did not say much, but the defendant number 2, Lord, he strenuously argued on that issue that whether Ram Prasad Mehra had any title at all or not. Lord, I mean, reply, Lord, I will not waste your Lordship's time. Lord, kindly straight away comes to the plain. Just to show, Lord, what was the plain case. Kindly comes to paragraph number 7 of the plain.
Yes.
Now, the 5 brothers registered deed of gift dated 1974. This is the impunity. This is the deed. Now, Lord, this fact was reiterated in our written statement also. We did not dispute this. None of the defendants did. Defendant number 2 Lord, took this point. Kindly takes Lord their written statement once. Kindly comes to Lord, paragraph number 9 of their written statement. Your Lordship kindly got it, Lord. With reference to paragraphs number 1 to 7 of the plain, the same are matters of record. 7 of the plain, I have read it out for your Lordship, Lord.
Yes.
So it is an admitted case in their written statement also.
So they are not denied.
No, not only denying, they have said, Lord, it is a matter of record.
Correct. That's
And
why.
that they have affirmed and verified true to their knowledge. Your Lordship would find that at page 8 and 9.
Yes.
The verification and affidavit.
Yes.
This statement is true to their knowledge. Now, Lord, kindly takes Lord the evidence, witness action. Look, this submission I had to deal with this aspect. Else, Lord, I will only restrict my submission to law and nothing more.
Yes.
I assure Lord, my learned friends sitting here.
Deposition of?
Lord, the deposition of the plaintiff.
Yes.
Your Lordship would kindly take
Deposition of?
Lord,
Ricky Mehra.
number.
Ricky Mehra.
Ricky Mehra, I'm grateful. Lord, your Lordship would kindly take question number 28 onwards. That's the cross-examination. Starting. Question number 28. Not from 28 onwards till Lord the end. Lord, just cursorily your Lordship would take a look, have a look. There's a question on the 96 settlement. There is a question of when they were born, about the knowledge. Rather, Lord, my case was espoused by different number 2. Lord, I had indicated when I made the submission. Lord, question of Lord, steps taken from 2012 also. Kindly comes over, Lord. Hurriedly, there is a page, question number 60. There's a issue of 1991, 1992. Death. Again, 96, 94. Lord, question number 100. Here, the plaintiff's admission that there are other heirs. Lord, these are not important. What I'm trying to show to your Lordship is
the entire plaint case was thoroughly cross-examined, but there is not a single question or a suggestion even, Lord, on the availability or non-availability of that gift deed of 1970.
And that's why, because your specific case is that they have relied upon this deed. And their question is that once the deed has been executed, the property has been shifted, so question of making them party does not arise. It is their case. Now your case is that if it's the deed, then they have to prove the deed.
My case was not that. My case was, Lord, because Ram Prasad Mehra became a title holder by
Correct.
virtue of that gift deed.
Correct.
So after Ram Prasad Mehra, it went, Lord, it devolved upon all the heirs of Ram Prasad Mehra under, Lord, the Hindu Succession Act.
Correct.
And that will include the daughters as well. Whether that case was made out or not, Lord, that is not subject matter of today's argument. Today's argument will, the law will take its own course. Whether I say that Usha Mehra is existing, but she will not get a right. Lord, that does not take away Lordship's, Lord, discretion or, Lord, jurisdiction to enter upon, Lord, into the dispute that there is an existing, Lord, heir who has not been made a party.
And only to clarify, our stand, or rather, the different numbers two stand, is that we had really taken a point. I had really taken a point that the gift deed was never exhibited. It has not seen the light of
That's
the.
I'm telling.
That's what I'm arguing.
That's I'm telling,
Yes.
because your case is that
There was even
no
if
deed,
there was
no deed was pressed before the court.
absolutely.
So question of
Just by averment, title does not pass
So
to.
that's exactly what I'm trying to argue. Lord, if the averment has been admitted to be a matter of record, an averment which has been admitted unanimously by everybody.
No. I
Lord,
have
that,
defied in the written statement as shown in the defied in the written statement.
Lord, I have shown your Lordship, Lord, the statement.
okay, you argue that. We'll
Now,
see.
Lord, if that is the case, Lord, under section 58, that particular fact is not required to be proved. Lord, may I place section 58?
Give the evidence.
And I shall also show, my Lord, the consequence of not cross-examining on a particular point or not giving suggestion on a particular point. What is the effect? When it comes to section 58, my Lord, of the Evidence Act once, Joseph Keta.
Yes, I mean.
Facts admitted need not be proved. No fact need to be proved in any proceeding which the party is here to or their agents agree to admit. Not the remaining portion not important. Kindly straight away comes to the last line, or which by any rule of pleading in force at the time they are deemed to have been admitted by their pleadings. Similar under by operation of section 58, I need not prove that fact. The question of exhibiting that gift deed, or tendering it in evidence takes a backseat. It's an admitted fact. Because they say it is a matter of record and true to their knowledge. And they have taken that point. The plaintiff cannot. Now, Lord, the effect of Lord not cross-examining them, we have shown the witness also. Lord,
Yes.
This Lord, this is
to 25,000 times.
AIR
case, my Lord, your Lordship has seen it many occasions. Something, my Lord, which is not been praised, it's deemed to be admitted. I don't think, my Lord, we should even waste my Lord's time on that. My Lord, just for the sake of Lord, what we had, we were relying upon paragraph 9. Lord, that has been approved also, my Lord, in a later Supreme Court decision, which your Lordship may or may not look into, but that this holds the field. That's 2019, volume 12, SCC, page 1.
Our argument was that in a partition suit, the first thing that they needed to show, my lord, that everybody was a party. Every joint, every co-sharer had to be made a party, my lord, in a partition suit. Admittedly, they have not made. Because they have said, why have they not made? They've given a statement that, look here, I have got title. By a statement, title, my lord, is not true. They have not been able to show anything, my lord, by which, my lord, the title, my lord, went to them. Nothing whatsoever. The only submission which was worth the answer, my lord, was my learned friend's argument, my lord, that the gift deed was not true. That gift deed is an admitted document.
Correct.
So once you are relying upon it, you can't come up and say that, no, this was not true.
Yes.
They want to say the sisters are entitled. I don't know. I might have said somewhere something else that the sisters, we were the. No, I say anything under the sun. I say, well, the High Court belongs to Mr. Cornwalker, which I say every day. But that doesn't mean that the High Court belongs to him. Title is something,
but he can execute the will to that effect.
But the probate court will not even see whether he has title or not.
He has to be with the two attesting witness. It can be probate.
Absolutely. So now,
so you keep the karmakar alone, not to keep alone with you.
Cormo and then Paul. Kindly, a very dangerous situation.
But kindly do not take a cognizance of all this.
There is a Cormo and then there is Paul. The entire the Shondi, as we say in Bengali, Cormo plus Cor. His part is very problematic.
Yes.
So that whatever I have said about title and whether I have denied, I have not, it doesn't matter. The title is something which flows from the law. So admittedly, the sisters who have been left out, they had a right in the property. On the last occasion when Mr. Mitra was making his submission, it fell from your lordship. So I'm not even, Lord, this was the answer.
So that's why Mr. Sarkar has given the detailed reply on that.
Absolutely. So there was no reply worth, Lord, something which would say that the rights have been relinquished. So jointness, which had to be in a hotspot, was never, Lord, brought into the hotspot. Those co-sharers, though they have a right, but they are not made party. So the entire suit failed. All the judgment that I had shown your lordship, Lord, was on that.
That is on, yes. Initially, you are argued on that point.
There was no answer to that. There was no
answer.
No,
they have given the answer by the
gift deed. Just by saying that gift deed is there, which is an admitted document. Which is an admitted document. Everybody realizes that, everybody accepts that. So that's not something that I needed to keep.
Yes.
They had spoken about approbate and reprobate. In a partition suit, there's no question of approbate and reprobate. Title cannot be approbated and reprobated. Title is there. Whether I say, whether I don't say, it doesn't depend on that at all. Title is an operation of law. By operation of law, the title has vested. Once it has vested, it can't be divested, by a...
Maybe other way.
Yes. These have taken care of. Probate obtained by Usha. Yes, yes. But it's very elementary, that the probate who doesn't go into title at all. It's elementary, and I've given you judgments on that also. It's not worth that. I don't know, why my learned senior friend made a submission about abuse of the process of law. I have really no. I don't know why he makes that submission, but he makes. And with respect to in a partition suit, everybody is a plaintiff and a defendant. That's absolutely
automatically.
So we can these are my things on reply. This is all with respect to the plaint reply in plaint. There is a counter claim. But the counter claim, has not been argued as well. The counterclaim I need to open, but any day your lordship pleases, not today. Any day your lordship. Achha. Before the vacation, but his vacation starts from next week.
No. That one.
From next week, because
I
his
think
senior- the entire city will not be there. So they will have to be there looking after that. So their vacation starts from next week. And
but the giving the work to the court.
On counterclaim, just after the vacation.
So far as the counter claim is concerned, the counter claim is only restricted to towards or against the plaintiff. So far as the defendants are concerned, I believe the defendants can file their written notes and thereafter conclude so far as this aspect of the preliminary decree is concerned.
Your lordship may decide. I'm saying, there cannot be a degree at all. Your lordship
And-
decides on.
No, we'll deal with it as the plaintiff, my lord, because we have to deal with the counterclaim argument. We'll deal it on the same day and also, my lord, give a note in respect of.
So you do one thing, all parties bring your written notes of argument on
Very
that day.
On that.
On that day. And whatever, I don't think the counterclaim you will take much time.
But 15-20 minutes. Fine.
If then,
Give a reply on that.
and only the plaintiff, you are not required to give.
I'm not required only as a reply to what has been argued and what has fallen from I learned senior. So far as the deed of gift. Deed of gift is concerned, that is of 18th of March 1974. That deed of gift has not been exhibited, not proved.
That
It
you
has
have
been
stated.
denied. It has been denied in the written statement filed by the defendant number 2. Defendant number 2 specific case was there was no further gift where the father has gone ahead and given it to, or the father has received any portion of the shares of the property. That's a specific case taken by the defendant number 2. So may not be I deny that there is a deed of gift is not there, but perhaps my case is restricted to to the fact that the father has not received any share. So in that event there ought to have been proved this this further division of or share being given to the father ought to have been proved and has not been proved. So section 58 will not apply. So that's my first submission. And with regard to the second submission is that which is really falling from the first submission, that is if deed of gift had to be proved, if the I'm sorry, if the deed of gift had to be, if the share which was they are proclaiming that they had been given to the father, they ought to have proved it by way of exhibiting that document. Now, this is really what had fallen from my learned senior, and apart from that, I believe
reply
I'm just I'll just
That's all.
yes, those are my respectful submissions. But I'll just give it and indicate in the note that I've denied that.
Bring all the notes on that day, and Mr. Chatterjee will take 20 minutes, and Mr. Mitra will take whatever it is. So I will complete. I will fixing a date.
I'll not come with my notes on that table.
So appearing for the plaintiff, so appearing for the defendant number 1, so appearing for the defendant number 2, and so appearing for the defendant number 3 series. You are appearing for? Please stop. Counsel for the defendant number 3 series has concluded his argument with regards to the plaintiff's case, but prays for time to argue with regard to the counterclaim. Full stop. In view of the above, let the case adjourned. Let the matter appear on 3:45 में नहीं होगा. 6th February 2025 at 3 p.m. All the parties are directed to come with the written notes of argument on the said date.
Great.
6th February. Great.
Item number 18.
Hello. Yes, item
18.
non-commercial. 18 तो बोला ना। नहीं वो तो रहेगा नहीं। Let the matter appear on कब देगा 345 एक दे दो। You are appearing 18 no 22nd January at 3:45 p.m. Let the matter appear on. Take next.
Item number 19. Here, my lord, I am the petitioner. If your lordship, my lord, recalls, Mr. Dutt appeared in this matter is a suit for declaration and cancellation. My injunction application was heard, and my lord, Mr. Bose appearing on the other side, my lord, was supposed to start his argument, my lord.
You are appearing for?
I am for the petitioner.
Petitioner, defendant, plaintiff.
I'm plaintiff. Plaintiff petitioner.
What application you filed?
My lord, application for injunction, and my lord, status quo order was passed.
Then readings completed.
Readings completed, my lord, and my lord, it was hard. And my lord, our argument was completed by Mr. Dutt. Mr. Shuman Kumar Dutt, my lord, appeared before your lordship, my lord, if recalls.
Then?
And my lord, Mr. Bose appearing on the other side was supposed to start his argument.
My lord, it was that matter, my lord, that the shareholders, my lord, few of the shareholders sold their shares to a single person. It was that matter, my lord.
Yeah.
My lord, I'm led by Mr. Bose, my lord. I can start for few minutes, but I won't be able to.
If he will not come, what purpose should be served? Whether he will come?
He is coming, my lord. If my lord says not today, my lord, not today.
My lord, today, my lord, the interim order is expiring.
Not
Constituents appearing for the plaintiff, constituents appearing for the defendant, counsel appearing for the defendant, arguing counsel appearing for the defendant. Counsel for the defendant submit that the arguing counsel is busy in the other court. Accordingly, the case is adjourned. Counsel for the plaintiff submit that the interim order granted earlier is going to be expired today and paid for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order granted earlier is extended till 22nd January 2025. Let the matter appear on 22nd January under the same heading. Next.
Grateful.
My application for rejection of plaint.
Section?
For rejection of plaint, your lordship.
Section of plaint. What is the ground for rejection of plaint?
Lordship, 3 grounds. Commercial, non-commercial. That there is no cause of action. Basically, to wiggle out from the admission.
Take rest.
I may be in some difficulty, my lord. They had to move their, my lord, order 7 rule 11. Let him start, my lord. There's a appeal item 1, my lord. I'll just come, my lord.
And also the third ground, I'm sorry, also I could not recall it in my notes, was that there was no demand made, so therefore no cause of action. Let's say the first ground being.
I think both of them needs some breathing
That's
time.
I'm telling.
We came running together from the library.
I was waiting, their bench did not set, so I was, my lord, sitting. I think they have been running around.
If your lordship takes up the application.
GA2?
GA2, your lordship.
Yes.
The plaint at page 10, your lordship.
Page 10?
Yes, your lordship.
Page 10 is the
plaint.
Account. Page 10 of the plaint.
Page 10 of GA3, your lordship.
GA3.
There are 3 applications, your lordship. One is for
That's
under
you are
chapter
moving the order 7 rule 11.
Order 7 rule 11.
That is a J10, J3.
J3, your lordship. One is under chapter 13A. The other is my application for acceptance of written statement, which is J2.
And
Yes.
GA3 is my rejection of plaint.
Yes, page 10.
Lordship kindly comes to page 10. The first two paragraphs for the showing that this should be filed in a commercial suit. Lordship kindly takes a paragraph 1. The defendant carries on business of dealing in furnishings under the name and style of skipper from such and such within the jurisdiction aforesaid. In the usual course of business, the defendant is known to the family of the plaintiff. So the relation established between the parties is also through business. And the second paragraph, first three words are the most important. For his said business, the defendant requested the plaintiff for a short-term loan. So here, your lordship, again, the loan was for the business of the defendant, and it was not a friendly loan. Your lordship kindly remembers Lady Moon is on the point where there was a friendly hand cash loan. This is a transaction wherein the money has been transferred through bank account. It's not a hand cash loan as considered under Lady Moon.
I have my lord's.
So I am aware there's a judgment against me in the other matter which I have suffered an order, your lordship. But your lordship, I would like to distinguish Lady Moon on the fact that there was a friendly hand cash loan.
Have you challenged that order?
Not yet. I have no instructions, but I don't know yet. So your lordship, in Lady Moon, it was a hand cash loan, and here the money has been transferred to bank account, and it is specifically pleaded that it was for the business of the defendant. As well, in paragraph 1, they also state that the relationship between the parties arises out of the business relationship between the parties. Therefore, your lordship, this suit ought to have been filed in the commercial division and not a non-commercial. With your lordships, kindly, I have a leader in this matter, Mr. Mukherjee. If your lordship may allow him.
Yes.
Grateful, lordship.
Lord, in this suit, there are 3 applications before my lord. One is IAGA number 1, which is an application taken out by the plaintiff for final judgment, summary procedure.
Yes.
Second application in Order 7, Rule 11 application taken out by me for rejection of plaint. And third application is, my lord, extension of time to file written statement. That is also by me. Now, my lord, Order 7, Rule 11, I have taken 3 points of maintainability. On that ground, I am seeking dismissal of the suit, rejection of the plaint. And if not rejection of the plaint, those grounds are good enough to resist the Chapter 13A application for it to proceed to trial. I have an additional defense on merit, my lord, which I have disclosed in the affidavit in opposition. Now, my lord, my learned junior has already indicated that one of those points of maintainability is the, my lord, point that the suit should have been filed before the commercial division. I will not labor too much on it because my lord has heard it at length. Only one more thing I would like to add, my lords. Lady Moon judgments and the other judgments also, which has been passed by various courts, including my lord, they proceed on the basis from the reading of the plaint. It appears that it's a friendly loan and a hand loan. Now, my lord, if my lord kindly sees the plaint which has been annexed to the Chapter 13A itself, my lord will see that here the plaintiff's business or plaintiff's occupation is not mentioned. Says that, does my lord have the plaint? It starts at page 11. Paragraph 1, defendant carries on business. Paragraph 2, for the said business defendant. So he knew that the loan was given for business. Now, plaintiff agreed to give a loan. Now, nowhere there is any mention that there was any acquaintance or this is a friendly loan or anything. One thing that is clear from the plaint is that they had given a loan for the purpose of meeting the finances with regard to a business. This is the only thing that I am pointing at right now. Second of all, my lord, on this basis, if my lord is not satisfied that on this ground the suit cannot be dismissed, then I will go on to my merit, which I'll address subsequently, that this was not really a loan, this was an amount given in investment, and I should be given an opportunity to lead evidence and prove that in trial, because if I am able to successfully prove that this money was not given to me as simpliciter as a loan, but it was an investment in my business, then perhaps the Commercial Courts Act will be attracted. But that we have to wait for trial till that. There are 2 more points that I want to urge before my lord so far as maintainability is concerned. One is, my lord, that the plaint does not disclose any cause of action. And 2, my lord, the plaintiff in fact does not have any cause of action. Why do I say that? Kindly comes to the plaint itself, my lord. Kindly sees that paragraph 3 of the plaint states that 10 lakh was given to the defendant by transfer.
Paragraph?
My lord, paragraph 2 kindly takes first of the plaint.
40,000.
That's my only attention that I want to draw to is, my lord, the tenure of the loan, which is 91 days.
40 lakh.
Yes, my lord. 40 lakhs. My lord is looking at CS 177 or 176.
176 GA3.
Item number 20 contract. I'm sorry, my lord, I was addressing from the other matter.
GA कौन सा केस चल रहा है?
GA 20 का कौन है? Item number 177.
176 का दिया रिकॉर्ड.
My lord, more or less the facts are same, the defendants are different and the quantum of loan given is different. But since my lord 177 kindly comes, my lord kindly sees paragraph 2, the loan amount is 10 lakh.
Give the plaint.
My lord, chapter 13, page 11, the plaint is annexed, my lord.
You're 3.
My lord, IAGA, this is my lord IAGA 1.
You are arguing which matter?
My lord, IAGA 3.
Order 7 Rule 11.
Order 7 Rule 11 I'm arguing. I'm showing the plaint from my lord IAGA 1.
Give the IAG.
Because ultimately, my lord, I'll also have to address on the chapter 13.
Okay.
My lord, kindly comes to page 11. Why do I say that the plaintiff does not disclose any cause of action?
Yes.
Paragraph number 2 is the amount mentioned is rupees 10 lakh.
Correct.
My lord, the tenure is important. Only this aspect I want to harp on. It's 91 days.
Correct.
So after 91 days, the right to sue accrues. The cause of action begins. Now kindly sees, my lord, paragraph 3. Upon request made by the defendant, the plaintiff agreed and gave the loan of such and such from the plaintiff's bank account. And my lord, thereafter, kindly takes...
I think the similar judgment is passed.
Yes, your lordship. On the extension of loan, my lord.
The similar fact.
Yes.
Extension of
very similar.
My lord,
similar.
My learned friend forwarded me the judgment by which he suffered the decree.
Similar
That was on,
fact,
my lord,
similar
commercial dispute.
No.
And number 2 was, my lord, limitation aspect.
Similar fact.
I'm not pleading limitation as a ground of defense, my lord. I am saying...
In that case, the cause of action as well as with regard to the money lender, third is with regard to commercial.
Your lordship is referring to the judgment of 19th September 2024. Sajjan Kumar Agarwal versus Stellar and others. The other 3 matters which was heard by your lordship.
Lord, that ship was Tanay Loya and Pooja Loya. Lordship, I'll just indicate with the leave of my senior, the distinction here is, there, your lordship, we had received the notice of demand as well as the loan was terminated. That's why the point of limitation was only on the issue of Supreme Court's in view of...
Not that.
Very, very lordship. Your lordship, I'm sorry, I'm giving your lordship my copy. Your lordship is talking about this judgment.
I'm sorry, my lord, I'm not aware of this. I'll have to consider this and come back. But I just wanted to indicate the point so that...
No, Mr. Kothari had appeared.
Lordship, in that... No, your lordship, that's what I'm indicating. Lordship is right. There was a point of limitation in that as well. But there's a... Pooja Loya and Tanay Loya, your lordship. Lordship, there's a slight distinction there. There was an extension of loan from time to time in that matter, and thereafter it was specifically terminated, and a demand notice was issued to me in that matter. Lordship, here the difference lies is that there was no extension of time, and then no demand was also served on me. Okay. That is the point here, your lordship. That is why there's a slight difference.
The transaction, the first one transaction, second again 10 lakh rupees, then it continues, you're not paid, then no notice and termination.
Lordship. But your lordship, I have indicated the difference, my lord.
May I, my lord? My lord, I'll just, before I place the, I'll just indicate so that my lord, when there is an extension of a loan, it has to be 10 days, 20 days. And it is only after the expiry of that extended period the cause of action arises. Here there is a pleading that the tenure of the loan was extended. But till what date, that is not pleaded. So if that date is not pleaded, my lord will not be able to come to a conclusion as to the date on which the cause of action arose.
Correct.
That is why I am saying non-disclosure. Kindly seize, my lord.
So first your question with regard, leaving aside the commercial. Yes, the first question is that if it is a 91 days, yes. 91 days. Yes. If it is 91 days, time starts from there.
91 days.
After 92nd day.
Yes, 92nd day he can file a suit.
That's right. From 92nd day, the time starts.
Yes,
so from 92nd day, it has to be taken for the 3 years recovery.
No, my lord. I'm not even going into limitation 3 years. I am saying, just like in 91 days, we know that he can file a suit on the 92nd day till 3 years.
No problem.
I am saying here there is no 92nd date. The date is not mentioned. He said, I have extended the loan. But for how long? It's not mentioned. It could be 1 month, it could be 5 years. If it is 1 month, then after expiry of 1 month, he can sue. If it is 5 years, then after expiry of 5 years, he can sue. He has not mentioned the date or the period by which it was extended. That is why I'm saying, my lord, non-disclosure of cause of action. Kindly seize, my lord, paragraph 6 at page 12 of the plaint. After 91 days, this is the second paragraph that I want to show.
Paragraph 6.
Paragraph 6. Kindly seize, my lord, at the request of the defendant, the time for repayment of the loan was further extended from time to time. And the defendant paid interest such and such for subsequent periods by checks dated such and such and such and such. But it does not say further period was extended by 1 month or 2 months, no period mentioned. So if no period is mentioned, there is no clear right to sue. From the rest of the plaint, from paragraph number 7 to paragraph number 15, my lord will not see that there is any pleading which says on which date the cause of action arose. If it was extended by 1 year, then on 1 year, first day, his cause of action would arise. My lord will not find any pleading which says that on such and such date, the extended period expired. And even in case of an efflux of, termination of lease by efflux of time, my lord, time has to be mentioned on which date the cause of action arose. Entirety of the plaint, my lord, scans, my lord will not find the period by which it was extended is specifically mentioned or a word. So that is why I say the plaintiff does not disclose any, the plaint does not disclose any cause of action. There has to be one particular day on which the cause of action accrued in favor of the plaintiff, not one single averment, my lord. I'm sure my learned friend, if there is any such averment, my learned friend will point it out right now. But kindly takes it from me, there is no such averment.
So if then take it to that, but what about the checks?
Yes, my lord. Checks I have paid. And it has been stated in paragraph number 6
That's why
that the
in
checks I have
6,
paid for interest.
In the 6, it is stated the time to time the repayment loan was extended.
Yes, my lord.
Correct.
Yes, my lord.
And the defendant paid interest.
Yes, my lord.
Correct. Interest so and so for the subsequent period by checks dated so and so 18 and 19.
Yes,
so
my lord.
2 checks you admitted.
Yes, my lord.
So it cannot be read together. This is extended, and this check which you have issued, you admitted it. It has
For
been
payment of interest, my lord, not for repayment of loan. Had it been
when the interest occurred, unless you paid the rent.
My lord, interest I will be paying on loan. If I take a loan from a bank for let's say 5 years, every 1 month I will be paying the interest of it. But that does not mean that the bank, on the basis of my payment of interest, can institute a suit for recovery of the money prior to expiry of those 5 years. He's entitled to interest. And if he can show that the terms and conditions of the agreement say that one default, I can recall the loan.
Cause of action they mentioned.
My lord, that is where, my lord, there is no such prayer, my lord. There is no particular paragraph with regard to cause of action. Paragraph number 11, defendant plaintiff has demanded payment of its dues, but the defendant has failed and neglected to pay the same. That is the cause of action, no dates mentioned. Now the plaintiff may make out an alternative case that this is not a case.
Finally come to the paragraph 18.
8. Yes, my lord. This is my second point, my lord.
7 and 8.
Yes, my lord. My first point is, if the tenure was extended, you cannot terminate unless the agreement gives you the right to terminate. In the bank loan agreements, my lord, we know we miss one installment. There is a clause which says they can recall the entire loan and call for the entirety. This is not a case of written agreement, because if written agreement, then it would be a commercial dispute. There is no pleading that there was any oral agreement that on one default I can, or I had the unilateral power of recalling the loan. But let us say for the moment, my lord, let us assume that the plaintiff is trying to draw the cause of action or the jurisdiction of this court through paragraph number 8. Kindly seize, by a notice dated 13th of July 2020 issued by Sri Shubir K. Mukherjee, advocate, on behalf of the plaintiff and sent to the defendant on his email ID, Kamalesh. Kindly mark, no, kindly, my lord, kindly keeps paragraph 8 and kindly check the spelling of Kamalesh. It is Kamalesh. That is not the name of the defendant. The defendant's name is spelled Kamlesh. Kamlesh. Kindly takes the receipt which was issued by the plaintiff defendant, my lord, after receipt of that amount of rupees 10 lakh. That, my lord, will find at page 7 of my page 7 of the chapter 13 application, my lord, annexure A. Page 7, my lord, of IAGA 1.
Page 7.
Yes, my lord. Page 7 of IAGA 1, the first annexure by which I signed on a money receipt saying that I have taken rupees 10 lakh, my lord.
KMLES.
My lord, will see right at the bottom the email address is mentioned. That is KAMLESH. And my lord, in paragraph 8 of the plaint, the email address is mentioned as Kamalesh. Now, my lord,
yes,
kindly comes to page number 10. Although it has been mentioned that the demand was made by way of an email, at page 10 there is no email. If there was an email, there had to be a 65B certificate to obtain a decree at chapter 13A stage, my lord, because one is trying to avoid trial. But kindly see page 10, this is not an email. And even at on the left portion, 5th line from the top, the email is mentioned as Kamalesh, not Kamlesh. So, my lord, if a demand justice...
Where from you are getting?
My lord, page 10, on the left-hand portion, there is 13th of July 2020, the date is mentioned.
Acha, Kamalesh, yes.
Yes, my lord. So, Kamalesh. So, this is their own document. At chapter 13A, if you have to secure a decree, you will have to plead that there is no good defense and the documents which are on record are sufficient for the court to pass a decree in the matter. Now, on this basis, my lord, on the face of it, I don't need to even...
No notice is served.
No notice is served on me. Not only that, my lord. Kindly compares paragraph 8 paragraph 8 of the plaint at page 13, where the incorrect email address is mentioned, Kamalesh at Skipper Furnishings, with paragraph 9 at page 3 of the chapter 13A application, my lord. I do not know whether this is an oversight or this is some malafide act, but the email address which was pleaded in the plaint incorrectly suddenly becomes correct in paragraph 9 of the chapter 13A application. Because here they say that they have
13 application is GA?
My lord, IAGA 1, my lord. I am showing everything from IAGA 1. Page 3, my lord. Paragraph 9.
Achha.
Kindly sees paragraph 9, upon dishonor of this is a replication of paragraph 8 of the plaint, but everything is fine, but only Kamalesh becomes Kamlesh suddenly. So on this incorrect application, no decree can be passed. And in fact, I have tried to demonstrate that there is non-disclosure of cause of action. And my lord, even if the plaintiff says that they have cause of action by way of the demand notice, number one, the demand notice was sent by email, no email annexed, no 65B certificate given, and even the document which purports to be an email or a letter is addressed admittedly to an incorrect email address. So no demand notice served on me. Now, my lord, these 3 submissions, including a commercial dispute point, my lord, they are the grounds on which I am seeking rejection of the plaint. They are also the grounds on which my lord, I want to resist their chapter 13 application. Final judgment should not be passed in this case. This case should proceed to...
So your ground in the chapter 13 and order 7 rule 11 are the same.
I'm arguing both the applications together for the convenience of my learned friend as well as this honorable court, my lord. So, my lord, so these 3 arguments that I have raised in order 7 rule 11 is also a defense in the chapter 13A. I have an additional defense which my lord will find in the affidavit in opposition to the IAGA that I have filed. This is a defense on merit, my lord. I say that it was not a loan simpliciter. This was an investment that was made in Skipper Furnishings, which is carrying on business as the plaint itself admits. And my lord, there was a lock-in period within which they were not supposed to get payment. We were supposed to only pay interest. I have paid the interest. There is this was pursuant to oral agreement. My lord, will kindly take the affidavit in opposition. I'll place the paragraphs. I don't want to take too much time. Kindly sees the affidavit in opposition. My defense starts from paragraph 4A at page 2.
Yes.
My lord, page 3, my lord, see, I have pleaded the oral agreement that was reached between the parties. I have given the clauses. I have stated that subpara 4, the total amount of rupees 50 lakh would be treated as an investment. They were supposed to give me 50 lakh. They only gave me 10 lakh. I gave them the interest back. They realized that My lord is suppressing a laugh.
Yes.
Should I stop arguing, my lord?
No, continue, continue.
তোমার কথাটা কানে ঘুরে এসছে। We were supposed to get 50 lakh. We got 10 lakh. We did not get the remaining 40 lakh. There was a lock-in period, my lord. And we were supposed to make bi-monthly payments. And I have specifically stated that this amount was given as investment. If I am allowed to proceed to trial and prove this, my lord, then even if this friendly loan or hand loan aspect is there, my lord, an investment amount given for investment towards business purpose would be a commercial dispute. My lord, these are my only 3 submissions. Lady Moon, my lord, if my lord has seen Lady Moon many occasions, Lady Moon, I believe I had handed up the judgment once. Paragraph numbers 13 and 20. It proceeds on the basis of the friendly loan. My lord has probably seen this judgment 10 times in a single day. So I'll not place this. But Lady Moon was.
He is the victim of lady.
Yes, yes. My lord, logistics দেখিয়েছিলে? There's one judgment which considers Lady Moon. In Lady Moon, my lord, the dispute was filed in a commercial. And I'll just indicate. Lady Moon.
So as per your case, the paragraph 4, affidavit in opposition, which is your defense.
On merit, my lord. On merit. But that
On
is only for chapter 13A. So
Correct.
far as the other defenses are concerned, they are both in order 711 as well as chapter 13A. But there's another judgment of Padma Logistics and Khanij Private Limited versus Ideal Unique Realtors Private Limited. It is reported in 2022 SCC Online, Calcutta, page 126, my lord, where Lady Moon was considered. নিশ্চয়ই আমি এক্ষুনি দিয়ে দিচ্ছি আছে কপি দেখুন একটা এই যে I've got it এই যে না করতে হবে my lord in
Yes,
my lord, in Lady Moon, my lord, the suit was filed in the commercial division. It was held that it was not a commercial dispute because it was a hand loan and the plaintiff was returned. In this case, my lord, in Padma Logistics, my lord, the suit was filed in commercial division. But despite this being a simple friendly loan, my lord, it was held to be a commercial dispute. Kindly takes paragraph 12 of this judgment. But my lord, after considering the arguments advanced by the parties, the honorable judge says, I do not find merit in the argument of the respondent that this is not a commercial dispute within the meaning of the Commercial Courts Act 2015. On the contrary, I am of the view that this is a classic commercial dispute which falls within the ambit of section 2C(I) of the Commercial Courts Act 2015, read with explanation A to section 2C of the Act. The case cited by the respondent of Lady Moon Towers Private Limited is inapposite and distinguishable to the facts of the instant case. In the said decision, it was held that the loan transaction was a friendly or hand loan and had been advanced without execution of any documents or mercantile documents. I find that in the facts of the instant case, there is more than one document executed by the parties to support the conclusion that this is a commercial dispute.
That is the document is there.
That document, on the basis of which, my lord, that is that money receipt that I am showing, that it was mentioned as a loan, my lord. The document which shows the correct email address of the Kamlesh Agarwal, that is the only document that I can refer to as a mercantile document, subject to what, my lord?
What document? This is the mail that is they have sent.
My lord. No, not the mail, my lord, the money receipt.
Where is the money?
Money receipt at page 7, my lord.
Of AIU?
Of IAGA 1, my lord, that application.
Page
Sorry, my
7.
lord, there are so many applications and counter applications.
Acha, received.
Yes, my lord. I also find the facts of the instant case pertains to an ordinary transaction for realization of monies, and there are mercantile documents which have been executed by and between the parties. I am also of the view that the negotiations and documents which merchants undertake ought not to depend on the subtleties and niceties of law, but are best left to their commercial wisdom. One more thing I must draw my lord's attention to is that friendly loan, hand loan, these words, any friendly acquaintance, nothing is there in the plaint. And my lord will see item number 21, Sulochana Poddar versus Kamlesh Agarwal. Another Poddar has given me a loan. So there cannot be multiple friendly loans. These Poddars are all relatives. On the face of it, there are documents, there are pleadings, there are more than one case pending before this court, which is a friendly loan. Now the 5 friendly loans taken together, my lord, becomes commercial.
Yes.
The Poddars giving to the Agarwals, my lord. My lord, these are my humble submissions in respect of both the applications, my lord.
Okay, thank you. Next.
My lord, kindly first takes GA3, my lord, which is rejection of plaint. essentially, my lord, three grounds, my lord, for the application, my lord. One is, my lord, it's a commercial dispute. Now, this aspect of the matter is covered by your lordship's judgment, apart from Lady Moon today. My lord, if it is, my lord, on the basis of, not on the basis of a mercantile document, then Lady Moon, as followed by your lordship, clearly says that it cannot be a
No, they are with regard to their distinguishes my judgment as well as the Lady Moon with regard to page 7 of GA3, GA1. Money receipt.
GA1. I think that should be GA2, my lord, possibly.
GA1, para 7.
GA1 is chapter 13.
177. CS 177.
Lordship is looking at CS 177.
20 দেখাচ্ছে ভাই আমি ওই জন্য 177 একই ব্যাপার
It's all the same, my lord.
This is one thing. Second thing, paragraph 1 and 2, admittedly you have given the loan for the business purpose. These are the two things.
This is a receipt. My lord, page 7 is not an agreement. Page 7 is a receipt acknowledging, my lord, payment.
No,
of
they are
this.
telling, that's
Yes,
why.
they are saying. And my lord, possibly, my lord, drawing, my lord, some reference from this document, they have, my lord, cited this, my lord, Calcutta judgment of, my lord, Justice Kapoor. My lord, if your lordship takes note, the last judgment which he just now cited, kindly takes, my lord, paragraph 2 of that judgment. The brief facts culminating in the filing of the suit are that respondent had approached the petitioner to avail of short-term loan of a sum of 4 crores. It was represented on behalf of the respondent that loan would be repayable with interest so and so. Additionally, respondent was obliged to secure the loan pursuant to the aforesaid. Petitioner on so and so remitted a sum of rupees so and so by RTGS. The memorandum of understanding dated 13 June 2016. Sorry, thereafter parties entered into a memorandum of understanding dated 13 June 2016. The memorandum of understanding records that in view of the representation and assurances made by the respondent, petitioner had lent and advanced a sum of rupees 4 crores to the respondent repayable with interest at 15%. So what had happened was the, my lord, transaction of, my lord, money lent and advanced happened before on the basis of oral representations like in my case, but it was, my lord, followed up with a, my lord, agreement, which is the memorandum of understanding. And that is the reason why in paragraph 12, the learned judge records or returns a finding that it cannot be said that this is not a commercial dispute and was pleased to pass a decree on admission.
Yes.
So this is, my lord, the distinguishing feature. Here also, my lord, the document he is relying upon is really a receipt. There is no, my lord, follow-up agreement. My lord, this is acknowledgement of the sum receipt. There is no agreement between the parties in writing, which can be, my lord, termed as a mercantile document to fit into the definition of, my lord, commercial dispute within the meaning of section 2, my lord, 1C of the Commercial Courts Act.
And what about your admission in paragraph 1 and 2, business terms?
My lord, kindly comes to the plaint, my lord. If your lordship is looking at, my lord, now GA2 in CS 177, which is the rejection of plaint application.
GA1.
No, the rejection of plaint application is GA2.
Yes.
My lord, 3 paragraphs I would like to place. Defendant is into business, that is para 1. Last sentence of para 1. In usual course of business, the defendant is known to the family of the plaintiff. This is, my lord, how, my lord, he is acquainted to me. And, my lord, this is, my lord, the paragraph 2 averment is for the purpose for which he is asking, my lord, because of his acquaintance with the family member, the loan. And paragraph 3, my lord, upon his request, plaintiff agreed to give loan of rupees 10 lakhs to the defendant by transfer of the amount by RTGS. This itself, my lord, does not, my lord, satisfy the test of commercial dispute. My lord, there is, like I said, my lord, there is no, my lord, agreement today in writing which can, my lord, be termed as a mercantile agreement to, my lord, satisfy the test of commercial dispute. My action of giving him the money is by reason of him, my lord, the plaintiff knowing him through a, my lord, through the family. and that is specifically a word in paragraph, my lord, 1 of the plaint.
Yes.
Now, my lord, his next ground is really, my lord, on the cause of action thing, that the plaint does not disclose cause of action.
Yes.
My lord, apart from the plaint, my lord, first let us see, my lord, whether it discloses. My lord, kindly comes to page 10 of the plaint. My lord, paragraph 4 is, my lord, his acknowledgement and confirmation with regard to the receipt of the loan. This fact is now corroborated, since your lordship is also hearing the chapter 13A in the affidavit. The story which has been spun, my lord, is that no, you were supposed to give me not 10 but 50 lakhs, and this was the manner in which it was to be repaid. So, my lord, the admission with regard to the receipt of the money is now there. Then, my lord, checks were, my lord, handed over. In paragraph 4, my lord, we have referred to them, post-dated checks for 10 lakhs and also the interest. And we have been paid interest, my lord, on this amount. That is my averment in the plaint. Paragraph 5 is that averment. Check dated so-and-so for rupees 37,397 was encashed upon request of the defendant for extension of the loan. Check dated 11th October for 10 lakhs was returned to the defendant. So the principal sum check which was given as a, my lord, kept with me, I had returned because they wanted extension. Paragraph 6. At the request of the defendant, time for repayment of the loan was further extended from time to time. Defendant paid interest of rupees 12,329 and so for subsequent periods by checks dated 28 December 18 and 16th February 19. Then, my lord, a check was issued on 1st of April 2020. This is my cause of action now, for rupees 10 lakhs in favor of the plaintiff. Kindly comes to, my lord, page 11, third line. Upon presentation for payment, check was returned unpaid by the defendant's banker with the remark, drawer signature differs. Copies of the check and dishonor advice dated 20th June 2020 received by the plaintiff from his banker are filed here too and marked annexure B and C. This really is my cause of action for, my lord, recovery of this money which I have claimed in the suit. Now, my lord, there are two ways of looking at it. Lordship remembers, my lord, even this was during COVID. So I had, my lord, the time even after that period till 28th of January 2022 to institute the suit. I have instituted the suit in July 2022. Even, my lord, from the date, they have not taken that point, but cause of action, they say that there is no cause of action. This is really the cause of action.
5, 6 and 7.
5, 6 and 7 is the cause of action for which. So I did not go into, my lord, these all arguments that
Now the third is with regard to the what about the
demand notice.
Demand notice address.
My lord, that is really, my lord, not a ground available to them to, my lord, in a while here, my lord, arguing an application under Order 7, Rule 11. My lord, he has to restrict his case.
No, not if will not go to the Order 7, Rule 11, but if you go to the chapter 13. So we see.
My lord, I'll address on the chapter 13A. My lord, first let me, my lord, overcome this hurdle, my lord, of, my lord, the plaint being rejected. My lord, he says that the name or the email address of Kamalesh was changed, and therefore there was really no demand made to the, my lord, person concerned who could have responded or repaid. Now, my lord, I take his case to be at the highest, and I accept for the moment, my lord, what he is arguing is correct. My lord, the institution of the suit, the plaint itself would be treated as, my lord, a demand. My lord, the cause of action in the plaint is, my lord, June 2020. So, my lord, I am not, my lord, required to, my lord, separately, my lord, we give, my lord, recall notice. But today, my lord, even without a recall notice, my lord, the if institution of the suit would be a deemed recall of that, my lord, loan.
Why?
My lord, because, my lord, I have, my lord, pleaded in the plaint that the check which was issued for refund of the principal sum has now been dishonored. In addition, I have said that after that dishonor, I have issued an email. My lord, kindly visualize the situation. Without issuing that email, I had instituted a suit. Would that, my lord, suit be maintained? My lord, in my respectful submission, yes, I am asking for recovery of money. The plaint in that case would have been treated as a demand notice. I am not required to give a separate demand notice, my lord, for this purpose.
Yes.
So in all the three grounds which my learned friend, and this is not even, my lord, a ground available to him, my lord, under to challenge, my lord, the institution of the suit or the continuation of the suit, invoking, my lord, the provisions of Order 7, Rule 11.
Yes. Then
My lord, this could have been a good defense, my lord, in a proceeding under 138. That I did not get notice.
That is different thing.
So, my lord, these are my respectful submissions.
Then your 130 is never be maintainable.
Yes. Yes. Because that notice is statutory notice and it's important.
Yes.
So this is, my lord, so far as the rejection of plaint is concerned. Now, so far as, my lord, the chapter 13 application is concerned, my lord, again, for me also it would be, the arguments would be same.
Same, that's
If your lordship is with me so far as these arguments are concerned, I have an additional argument dealing with his, my lord, case in the affidavit. Now, this is a, my lord, story which has been
already stated. That's why he's telling that the court is.
Lordship, he has seen the smile in lordship's face. He understood why lordship and
Not that.
For the defendant, this is what we usually face.
so, my lord, this is, my lord, something which is not reflected from the documents preceding the suit which were entered into, at least the receipt. If, my lord, he is relying, my lord, the plaint, I have annexed that receipt. The receipt contains, or indicates his, my lord, acknowledgement about the receipt of the money. So far as terms and conditions are concerned, my lord, kindly comes to the plaint once again, my lord. While, my lord, deciding a chapter 13, a lordship has to only see whether there is any possibility of the defendant defending this claim if an opportunity is given to them to go for trial. Now, the best defense according to him would be, my lord, that I did not get a notice. My lord, the plaint was served. That is notice for him, my lord, that I am, my lord, asking for recovery. And what defense does he have to that? His defense is, my lord, paragraph. If a lordship takes the affidavit in opposition, his defense is really paragraph 4.
4A to P.
Yes, that is his defense.
4A to P.
Now, with this, my lord, defense, my lord, whether the plaintiff should be, my lord, or the claim in the suit should be relegated to trial is the question that will fall for adjudication. And this is, my lord, on oath, what, my lord, the defendant is saying regarding, my lord, the oral agreement, which is contrary to the receipt which he has signed. The receipt predates this oral agreement.
Yes, next.
And this affidavit, my lord, kindly also notes there is, my lord, although they say that we were supposed to, my lord, invest 50, my lord, if your lordship comes back to page 5 once, my lord, page 5 of the opposition. Although they say that we were supposed to invest 50 lakhs instead of 10 which we had given. My lord, is there one, my lord, document on record, my lord, which would suggest this story, my lord, to be correct? So on the face of it, my lord, this does not deserve to be relegated to trial.
Yes.
And I am only asking, my lord, my principal sum with the interest which you had agreed. My lord, both the suits, there is another suit 176. There are similar applications for rejection of plaint and, my lord, for chapter 13, my lord, file. Only the, my lord, difference in the quantum. Yes. If lordship wants, we can give a one-page note. Otherwise, lordship can reserve it, my lord.
My lord, I'll just deal with the arguments, my lord, extremely briefly. First thing is very brief.
Only one. I'm sorry, my lord. Lordship had in a similar circumstances passed, my lord, decree, my lord, on admission, or my lord, chapter 13A. So, my lord, may I just, for completion, my lord, may I just cite that? Na Rito Banchila.
By your side.
Fortunately, not your lordship. I haven't suffered a decree yet.
First paragraph, lordship may take note, it was also a final judgment. Similar terms, my lord, of repayment in paragraph 2, lordship had taken note of. Interest checks were there. It's, my lord, actually fitting into the factual scenario. So, my lord, I am, my lord, relying upon it.
No, that's what I'm telling, because
where lordship had the occasion to deal with similar kinds of applications. Both rejection of plaint, here additional grounds have been taken, but lordship dealt with them.
This similar is with regard to the limitation.
Limitation.
Another one.
That Lohia matter. Yes. I was carrying that also, but limitation, I don't find them taking, my lord. Cause of action is something else, my lord.
They have not taken the limitation.
Yes.
The judgment that has been handed over to my lord, the defendant's defense was in paragraph 5, that there is no jurisdiction since cause of action arose outside, which is not the defense that we have taken. Secondly, it was in respect of limitation, which again we have not taken. We have taken the specific defense of non-disclosure of cause of action. The plaintiff does not have any cause of action and merit. So this judgment that way, my lord, the ratio is not is distinguishable on facts. So far as, my lord, the fact that our argument was made that there is no document to show that the defense has specifically stated upon negotiations between the parties, they entered into a concluded oral agreement. My lord, oral agreement.
What is your defense? That is the 4A.
Right, my lord, oral agreement. Next, my lord, the one thing that I want to show, although page number 7, which is the money receipt, it has been said that this is not a loan agreement. This is not a mercantile document. Kindly sees, my lord, the terms and conditions which has been pleaded in the plaint, the tenure, the interest and everything. This is, although the nomenclature may be a receipt, in fact, there is no nomenclature. It does not say it's a money receipt. My lord, this records the loan agreement. This is the agreement. Received with thanks rupees 10 lakh for loan, deposited for 91 days at 15% per annum through RTGS. These are the terms of the loan. So how can it be said that this is not a loan agreement or this is not a mercantile document? And next, my lord, the cause of action that says that the check gives the cause of action and not otherwise. My lord, the submissions made by my learned friend does not match with the averments made in the plaint, because kindly looks at paragraph number 9 of the plaint. The defendant duly received the notice but failed and neglected to pay the dues of the plaintiff. The defendant did not even reply. So their cause of action, clearly it has been spelled out that despite receipt of notice, non-payment made. Yes. How can now it be changed to know the check gave us cause of action? Well, these are my only harm. Yes. I learned it. My junior friend also wants me to argue. So, my lord, that the plaintiff's case is also that of an oral agreement. He does not say there is a written agreement. I have stated there is an oral agreement. But if the plaintiff's case is to be believed, even the document is to be taken as a loan agreement. It specifies all the terms and conditions. It's signed by the defendant, my lord. So they are holding the defendant liable. So once there is a written document, it has to be treated as a mercantile document. That's why commercial dispute, my lord. Yes. I'm grateful to him.
Grateful, my lord.
Suffering for the plaintiff, suffering for the defendant. The plaintiff has filed an application under Chapter 13. Chapter 13?
Chapter 13.
Chapter 13 is, my lord, GA1.
Original side rules, staying for summary judgment. Defendants have filed an application under Order 7, Rule 11 of the Code of Civil Procedure for rejection of the plaintiff. Hearing in connection with both the application concluded, CAV.
No, I think there is another application in CS 177 for extension of time.
GA3, my lord.
After this, if should survive, then it will be taken. If not survive,
grateful to my lord.
Next.
Item number 7 to 9.
May it please your lord.
Yes.
In the first suit, the evidence is to be done, the remaining part of the evidence, and the second and third suit, those are over. So
the witness present.
In this suit, for the evidence part, he is leading me.
Leading you.
As far as this suit is concerned, I am defendant number 3. I'm not in the other 2 suits. And what had happened was we filed our written statement. Then we did not get notice. So when the issues were framed and the evidence was taken earlier, we did not have notice of that. So therefore, we made an application for recalling the witness and being permitted. Now this order, your lordship will find in 20th of February 2023. In this order, a copy.
Yes.
There, if your lordship comes to, what's the thing?
Addition issue, page 3.
Yeah. Page 3.
Yes.
And after saying that the witness is recalled, they will be entitled to examine in chief. 1 and 2 will again cross-examine. Then defendant number 3 will cross-examine. Then middle, the additional issue, if required to be framed at the instance of defendant number 3, shall be done once the suit appears. Well, today it's appearing. Last 2 times it appeared, but there was time was taken. The witness wasn't there. But that additional issue has to be framed. In my respectful, we have prepared a suggested issue.
Is out.
No, just one, because I am claiming that
আমি just একবার দেখে নিই।
Well, Mr. Ghosh is there, he can agree to it. Or because my case is a bit different from defendant 1 and 2. I'm saying in this property, it was vacant. I was inducted. I came in. There was nobody was claiming to be the owner. I've been there from a long time.
What is the case? Adverse possession?
Yes, so they have no this thing. So it's a different case from the other
I'll
two.
frame these 2 additional issues and my witness is there.
And the other, it is the first issue is there. I think 22nd March was the order of 2022 order of issues.
Only Milord, for the future reference, may I humbly submit, is it your lordship pleasure to record all the issues in a particular order? So that in future, yes.
Because it will affect defendant 1 and 2 as well.
We understand, my lord, a complete different case than what the defendant number 1 and 2 was, my lord, actually arguing. My lord is being now.
No, that's why they've been given the chance to cross-examine.
Only 5 issues were there earlier.
Earlier 5 issues, and now these 2 issues will be added.
So today I will recast along with
Amal.
Only thing, the first issue is it maintainable? So one of the points I would be taking is whether if I am a trespasser, if I may put it this way, that if I am a trespasser in my own right, then 2 trespassers can't be put in one suit. So that maintainability issue will go. If I succeed in this, so the maintainability is there, my lord. As
if there is conflict between their interests,
so plaintiff need not to do.
No, it's vis-a-vis plaintiff and me. The point
no,
that
there are two trespassers, meaning
Correct.
thereby
who
1 and 2 and 3.
Causes of action will be different against both.
Maybe this is for the first time.
So that is there. I'm just putting my friend on notice. We will also that is the suit maintainable is there. So these 2 can be
added. That is why I requested your lordship to jot down all the issues, the original one and
Okay, start here, then when I will take the order, I will.
One more item. If my learned friend finishes his chief today, Mr. Bose is also not here. He will. So we were requesting that we can start the cross-examination on the next.
Let's first the chief.
Let the chief be over.
Will take?
I have 10 questions.
Okay.
Great.
Sir, repeat after me.
My name is Vinod Kumar.
I solemnly affirm
I solemnly affirm
that whatever I depose
by
way of evidence,
intent,
I shall speak the truth.
shall speak the truth and only truth.
No part of it shall be false,
No part of it shall be false,
and I shall not conceal anything.
and I shall not conceal anything.
What is your name?
Vinod Kumar Poddar.
Examination of the plaintiff on recall, na? Examination in chief of the plaintiff on recall.
Father's name?
Late Badri Prasad Poddar.
On recall.
Late Bodri Prasad Poddar. Your age, sir?
76.
76. Occupation?
Business.
Business. Residential address. Speak slowly.
I have 2 address. One is B32 Film Nagar, Hyderabad, and 2 Guru Sadeh Road, Calcutta.
Further road, Kolkata. Yes, sir.
May I, sir? Mr. Poddar, the defendant number 3 has claimed to be in adverse possession in the suit property. What do you say to that?
I beg to disagree. He's a trespasser.
I'm showing you postal receipt. I'm showing you the original postal envelope appearing at pages 53 and 54 of the plaint. Please, copies whereof appearing at pages 53 and 4 of the plaint. Please tell my lord, what is this document?
My lord, this was the letter written to Ms. Dr. Debal Sen from Amalgamated Fuels Limited through registered post
Amalgamated Fuels Limited through registered
post with acknowledgement due, which has been refused by the party.
Document I am showing you document.
এটা seal করা খুলবো
Yes, but that seal has to be opened and
Record and order. The document produced by the plaintiff is in seal cover. According the Newpon Court, in presence of all the parties, the seal cover is open.
Please tell my lord.
On opening the seal cover, a document dated 31st of October 2019 is found. Full stop. The same was shown to the witness.
Please tell my lord, what do you say about the contents of this letter?
This letter is true, which we have sent to Dr. Dobal Sen, asking him that you are requested to send relevant documents with regard to your status and justifying your occupation in respect of the said portion within 15 days from the date of receipt of this letter.
From the date of the receipt of this letter.
If you fail to produce the relevant document justifying your occupation and possession of the said portion, we shall be compelled to file appropriate proceeding against you, and you shall be held responsible for the cost and consequences of the same.
DEBAL.
DEBAL.
How was this letter sent to the defendant number 3?
Your Honor, there were 2 letters sent, one by registered post, acknowledgement due, and one was sent by hand over there. The letter sent by hand was handed over to a staff member of Dr. Dobal Sen, who had taken the paper and signed and gave the letter back to my representative.
Was this letter delivered to to the defendant number 3?
This letter, the registered post acknowledgement due, was refused by Dr. Dobal Sen.
I am showing you the document, original document, copy whereof is appearing at pages 36 to 37 of the judge's brief of document. Please tell my lord, what is this document?
Your Honor, this is the a speed post sent by Amalgamated Fuels Limited to Dr. Dobal Sen in 87 Park Street, flat number 87E, ground floor, ground floor, Calcutta 7016, and the letter had been refused by Dr. Dobal said.
Please have a look at the letter dated 31st October 2010 and tell my lord who has signed on the said document. 31st October 2019. And please tell my lord who has signed the document.
My lord, the letter has been signed by Shabd Kumar Chaudhary and authorized Shabd Kumar Chaudhary, an authorized signatory of Amalgamated Fuels Limited.
What do you say about the contents of the letter dated 31st October 2019?
This is true.
The content should be. May I tender the letter, original letter, and the original postal document, my lord, as my lord exhibits. My lord, they may be exhibited correctively.
Original letter, if the letter is written to my client.
It came out of the envelope.
That is original postal. Original
letter and the envelope together.
Original postal envelope along with the letter dated
2019.
1st of October 2019. 19. Be marked as exhibit.
The number should be 3.
3. Exhibit 3.
Sir, आपको कोई जिज्ञेस करना है? सिर्फ आपने ही देखी हुआ है। देखी हुई है तो ना उठा उठा आपने ही देखी हुई है। हम उसी का नहीं होने का। आप तो कोई जिज्ञेस करना नहीं। बस करो ओके। Mr. Poddar, what according to you is the status of the defendant number 3 in the suit property?
Your Honor, defendant number 3 is he is an illegal tenant, or I can call him a trespasser.
Please write your lordship, not honor.
Okay.
That's all. That's all.
What are the other documents?
But there were, I had handed over in 2 documents. One is the letter, the envelope. The other had the postal documents.
No. That what the postal document which has been open in court that I exhibited.
Yes.
3. What are the other documents?
The postal receipt.
So that is not exhibited.
That is why collectively they should be exhibited.
Along with postal receipts. Then 3 collectively, huh?
The envelope containing the letter and the postal document.
Yes.
Will it be your lordship pleasure to keep it? Because I think Mr. Bose should start. I can also start.
It will come then February 1st week.
Witnesses from Calcutta.
Hyderabad.
He's from Hyderabad. You are in Hyderabad, residing in Hyderabad or Calcutta?
Yes, Your Honor, I live in Hyderabad.
Unless he
My
gets the
learned
property.
a friend is saying he had to leave Kolkata because we didn't give his property.
True, sir.
And then any date fix, your lord. Not the 6 except 6.
Then your client has to go to the
Your
Hyderabad,
Honor,
then he will take the property.
Except
Mr.
for
Dobal
6th of February. Except 6th, any day after 6th.
February.
Yes, sir.
January to नहीं तो
So and so appearing for the plaintiff, so and so appearing for the defendant number 1 and 2, and so and so appearing for the defendant number 3. Full stop. By an order dated 20 February 2023, this court has allowed the defendant number 1 and 2. And this court allowed the defend and the plaintiff witness number 1 be recalled, and if necessary, the plaintiff can re-examine, plaintiff can examine the PW plaintiff witness number 1 on recall, and thereafter the defendant number 1, 2, and 3 can also cross-examine the plaintiff witness number 1. Full stop. In the said order, this court has already given liberty, if required, and additional issues can be framed at the instance of the defendant number 3. Accordingly, the defendant number 3 has suggested 2 issues, which reads as follows. Is the number A, is the claim of the plaintiff against the defendant number 3 barred by laws of the limitation question mark? Number 2, is the defendant number 3 in exclusive, open, continuous and actual possession of the property, adverse to the title of the plaintiff? Question number 2. Full stop. The plaintiff has consented to frame the said additional issues, but submitted that the issues framed by this court earlier by an order dated 24th March 2022 be recasted along with these issues.
My lord.
Accordingly, the issue framed by this court on 24th March 2022 along with the suggested issues of defendant number 2 as defendant number 3 as mentioned above are recasted as follows. So you do one thing, the order dated 24th March, these 5 issues, okay, 5, then this will be 6, this will be 7. Great. Correct. Full stop. The plaintiff witness is present, plaintiff witness number 1 is present, and the counsel for the plaintiff has examined the said witness on recall, and during his evidence, one document is exhibited, being exhibit 3 collectively. Full stop. Counsel for the defendants press for time to cross-examine the witness. Accordingly, cross-examination of the plaintiff witness number 1 is deferred. Let the matter appear on 7th February at.
May I humbly submit this?
Yes.
My lord, 12 and 13 is the non-commercial day. So 2 days
12,
I want.
13?
Yes.
No problem. 12, 13? So I am fixing both days so that the cross-examination can be completed.
I think 1 day.
12 and 13? 3 p.m. both day. 12 and 13 February 2025 at 3 p.m. for cross-examination of the plaintiff witness number 1 by the defendants.
Grateful man.
Next.
The defendant number 3 first cross-examines, because after that written statement,
They are telling that you have to cross.
That is the difficulty now, my lord.
after the written statement of the my lord,
I'll talk to Mr. Bose if he wants. He's welcome. He to ask me himself to request your.
Yes, come. Mr. Bose has come.
Mr. Bose is here.
Yes, his work is done. তুমি আগে করবে না on the 15th of February. Very good.
So I am not fixing who for the defendants, either 3 star or 2 star, whatever.
I'm sorry, my lord, I was addressing it.
Oh, Mr. Datta was there.
Can be
So chief,
I was being led by Mr. Bose.
the chief recorded. Just take
Yes, I know. That's why I could be a little more less concerned.
Grateful.
Okay,
I'm very grateful.
Number 22.
My lord, I appear for the petitioner. I for the plaintiff, my lord. My learned friend's
Your Lordship,
application.
it's my
My lord,
application.
I am appearing for the defendant, my lord. My lord, I had taken out an application under Order 7, Rule 11 of the Code of Civil Procedure, my lord. My lord, I will humbly seek your lordship's pleasure to allow me to add on to this Order 7, Rule 11. I'll point out why, my lord. My lord, after going through the plaint, it appears that this is a commercial dispute. So, my lord, I don't know whether my order civil rule 11 is required to be heard if I can show that it's a commercial dispute, but I don't have that point in any of my pleadings. Your Lordship will kindly grant me a short time so that I can take this in my pleading in a supplementary affidavit, and then Your Lordship hears it out.
With regard to the commercial, you can argue orally.
My lord, let me then argue that, my lord. Let me then argue.
Orally, no problem.
Yes, my lord. My lord, kindly takes the plaint, my lord. And will kindly take my
GA1.
Yes, my lord. GA1, my lord.
उनको ना ऑर्डर 24 मार्च को ऑर्डर दे देना आज का सजेस्टेड इश्यूज फ्रेम में.
My lord, kindly comes to page 23.
हम फ्लैप करके रखते हैं देखो.
This is the plaint, my lord.
Yes.
My lord, the plaintiff is the owner of premises number 87 Park Street. And my lord, kindly sees 2. The defendant number 2 is a partnership concern, is a dealer under the defendant number 1. And my lord, kindly sees and is running the petrol pump at the suit property.
ए which क्या कौन सा सूट दिया आइटम नंबर
22 my lord.
Yes.
22 GA number 1 page 23 I have started my lord. That's the plaint.
Yes.
My lord, first paragraph describes the plaintiff as the owner of this property. And then paragraph 2, if your lordship kindly sees, the defendant number 2, a partnership concern, is a dealer under the defendant number 1 and is running the petrol pump at the suit property. My lord, when we talk about a petrol pump, my lord, on the face of it, my lord, it becomes that it is being used for, my lord, commercial purpose. Now, my lord also sees, my lord, since I'm arguing on both the entirety of the Order 7 Rule 11, then your lordship will find they say, paragraph 3, my lord, that there was an indenture of lease, which, my lord, is at page, starts at, my lord, page 37, sorry, my lord. This is between Shushanta Kumar Basu on one hand, and my lord, next your lordship will find Amalgamated Fuels Limited at page 41. This lease was granted to the plaintiff, and on the basis of this lease, my lord, the plaintiff had also given us, rather given to Bharat Petroleum, another back-to-back lease, my lord, for the purpose of, my lord, carrying on my business. That your lordship will find at annexure B, page 64. This is an indenture of 1952, my lord.
Yes.
Your lordship will find just after 1, 2, 3, 4, 5, 6, 7 lines, my lord. It ends with and in a capital. Burma Shell Oil Storage and Distribution Company of India Limited.
Yes.
Of Hong Kong House, such and such. When the witness said that the lessor do hereby demise unto the lessee all that piece and parcel of land described in the schedule hereto, containing an area of such and such, for a term of 15 years to commence from 24th of April 1952. Monthly rent of 5,000. It kindly comes to the first recital. The premises shall be used as a depot for storage and sale of petroleum products. So, my lord, it is on the basis of this lease, my lord, admittedly, that they have initiated this proceeding. Now, let's come back to the plaint, my lord, once more. My lord, at paragraph 3, they talk about this lease. At paragraph 4, my lord, at page 26, they say that this Burma Shell was acquired by the central government and it continued in possession. Then kindly comes to page 27, Malat. Burma Shell changed to Bharat Petroleum. That is the defendant number 1, Malat. I am for the defendant number 2. Being the defendant number 1 herein continued to remain in wrongful and illegal possession and occupation of the suit premises by paying occupation charges to predecessor in title of the plaintiff. The defendant number 1 continued in occupation of suit premises as a tenant in sufferance, never accepted as a statutory tenant. But therefore, till now, we find two things. That is, I am in possession. I am using it for a petroleum product and storage of petroleum product, and it's a petrol pump. Then kindly see, this is my second point, or rather the first point in Order 7 Rule 11, because it's more in the nature of Order 7 Rule 10, because your Lordship might have to hold this as commercial and give the plaint back. Now, my Lord, in Order 7 Rule 11, kindly takes para 6 at page 27. Sometimes in 1981, after the promulgation of the Calcutta Thika Tenancy Act, the defendant number 1 wrongfully and illegally claimed to be a Thika tenant in respect of suit premises. Defendant number 1 also filed a writ petition, intended praying for an order seeking leave to deposit the rent for this honorable court. The plaintiff, by a notice of 28th July issued through his learned advocate, gave the quit and vacate notice. So that is his case. This is his case. Now, since my learned friend has referred to the Thika tenancy, under the Church of Christ judgment, it plays that I can refer to documents which has been mentioned or spoken about in the plaint. So accordingly, in my application under Order 7 Rule 11, it kindly comes to page 88. Well, I didn't find this is with reference to the same property opposition where I am being issued notice. Kindly sees 88 to auto fuel and service. Seen that?
Yes.
This is to inform you the ground and payable on ad hoc basis up to such and such in respect of return file number 64/80. Returning Bharat Petroleum Corporation Limited is rupees 1986.36.
Yes.
So, I am also receiving demands of rent from the Thika controller. So, this becomes a Thika tenancy, and knows in view of the Thika Tenancy Act, this court may not have jurisdiction, considering that they may not be the owners of the property. Your Lordship will also see at page 94. This is as back in the year 2011, This my learned friends did not disclose in spite of the factum that this talked about a Thika tenancy having come up and things like that. This is 2011, issued to both the defendant number 1 and care of me, requiring me to deposit ground rent.
Yes.
So, my point is, first is, it's a commercial transaction and it's a commercial property, Accordingly, this court, or it shouldn't be in the non-commercial side of this court. And my point in Order 7 Rule 11 is, that this is a Thika property. This court would not have jurisdiction because there's a bar on filing of suit. Now, it kindly takes their opposition, So, I must point out that the suit is in an undefended suit position at the moment. Will kindly see their opposition. Kindly takes, paragraph 5. At page 4 of their opposition, With reference to paragraph 2 of the application, He denies that I'm a Thika tenant. Now then says, I deny and dispute the petrol pump was constructed a defendant number 1 in his capacity as a tenant. I say that the defendant number 2 cannot run a case which has not been made out by the defendant number 1. But here is where I join the issue, Malad, because they have themselves mentioned about the Thika tenancy. So therefore, I can relate a judgment for that, Malad. And other than that, Malad, your Lordship will find paragraph 8 once your Lordship will kindly take.
Yes.
I respectfully submit. I'm just not reading the first paragraph. It's a regular paragraph, Malad. Next sentence. I respectfully submit. Scope and purport of WP number 405 to 1988 is completely different. It's for this reason. Different number 2 has failed to disclose the same. Malad, they have mentioned it. They have not disclosed it. I have only taken the point that yes, it's a Thika tenancy and these are the documents. And Malad will kindly see. There is no denial of these documents which I have annexed to my application under Order 711. So therefore, Malad, I humbly submit, Malad, that this suit is barred under the Thika Tenancy Act, Malad. And other than that, Malad, it's a commercial suit. Malad, my junior is there, I believe, Malad. If your Lordship kindly has a look to 2012 8 Supreme Court cases 706. Amrita.
45 minutes. Yes.
This, your Lordship, kindly see paragraph. Excuse me. Paragraph 10, if your Lordship kindly sees, Malad. First, Malad, so Order 7, Rule 11 is discussed. Then, Malad, next page, if your Lordship kindly sees, Malad, para 12 refers to the judgment of Arivandanam versus Satyapal. Then, Malad, kindly comes to the next page. Malad, kindly sees, Malad, paragraph 18.
Yes.
Malad, in the light of the context, we've gone through all the elements in the plaint. Para 4 of the plaint alleges that the second defendant as agreement holder and also as a registered parliament of the first defendant executed the agreement for sale. In spite of our best effort, we could not find any particular showing as to the documents which are referred to as agreement holder. We are satisfied neither the documents were filed along with the plaint nor the terms thereof have been set out. How many two documents were to be treated as part of the plaint as being the part of the cause of action? It is settled law that where a document is sued upon its terms and not set out in the plaint but referred in the plaint, said documents get incorporated by reference in the plaint. The position has been reiterated in US Sasidharan. And accordingly, Malad, if it is mentioned in the plaint, then I have a right to refer to that document. Because they have taken the point that I am making out a new case, but it is them who had taken the point of cause of action, Thika tenancy, Malad, in their plaint. Obviously, Malad, because they did not want to be attacked with the provision of the act of suppression. So therefore, they said that, but not in the exact terms.
Yes.
And accordingly, Malad, I submit, Malad, a court can always allow disclosure of a document which has been pleaded in the plaint but not disclosed.
Yes.
And Malad, for reference, Malad, for complete nature of submissions, Malad, your Lordship will kindly see, Malad, that this suit is barred, Malad, under the Thika Tenancy Act, Malad.
Give the Thika tenancy.
Section 21, my lord. It's a very wide, my lord, call, my lord.
Yes.
No civil court shall have jurisdiction to decide or to deal with any question or to determine any matter which by or under this act is required to be or has been decided or dealt with, or which is to be or has been determined by the controller of the appellate or other authority specified the provisions of this act. And no order or judgment passed or proceedings, including execution proceedings, commenced under the provisions of this act shall be called in question in any civil court.
Yes.
So, my lord, why I am submitting this, my lord? Because they are saying Thika tenancy, I bought that on record and clearly is available that the Thika tenancy controller is asking for, my lord, ground rent from me. Once that is done, my lord, that becomes a question now for the Thika controller. If they have any dispute, they can go to the Thika controller. But they have not done that. They have come before your lordship. But for the purpose of my lord, Order 711, I really don't have much more to say, my lord. It's a very small plaint, my lord. Your lordship has seen that. So that is it, my lord. Those are my submissions, my lord.
Thank you. Come on the next other matter. Sense appearing for the plaintiff, sense appearing for the defendant. Defendant has filed an application being GA1 of 2023 under Order 7 Rule 11 of the Code of Civil Procedure, praying for rejection of the plaint. In addition to the same, the comma, the counsel for the defendant has argued the matter that the suit is of the commercial in nature and is not maintainable before this court. Counsel for the defendant has concluded his argument. Due to paucity of time, counsel for the plaintiff could not commence the argument. According, case is adjourned. Let the matter appear on 8th of January 2024 under the same heading as parted.
Grateful, my lord. Grateful.
Time. My lord, may it please the lordship to fix a time, my lord.
Time then it will go to some February, March. One time, but February first week.
We'll take a chance on 8th of January.
Sure.
Grateful.
Mr. Bhattacharya wants to concede to my extension of time.
No. 700 something. 23.
Next matter.
But I am seeking for time to file affidavits.
To this?
Yes. 700 odd days delay. You cannot file a suit because
it was under scrutiny, not my fault.
No. I will also beseech your lordship to ask the department for a report on this. And they have made allegations against us.
Next matter, we will take Mr. Bhattacharya for scrutiny. Then they will
allegations against the ex-lawyer.
And he should now, as a senior advocate, not oppose these sort of phrases.
You can, but
yes, doesn't look good. Doesn't look good. He should say that very well.
File an affidavit.
Let there be an
this is the actual ploy. 6 applications filed. GA8.
Sense suffering for the plaintiff, sense suffering for the defendant. Police 23. The defendant has filed an application for extension of time to file written statement.
No. Writ of summons.
Filed an application praying for extension of time to lodge writ of summons. Police counsel for the plaintiff raised objection and submit.
For the defendant numbers 28 to Sunny Koto defendant 28 to.
No. Plaintiff has filed.
627-28.
Plaintiff has filed an application for extension of time to lodge writ of summons. Police counsel for the defendant raise objection and submit that he will file affidavit in opposition. Let affidavit in opposition be filed within. You are appearing soon.
May I submit this, Milord?
Once
I show that plaintiff is in scrutiny, no one can really say anything. What's happening in the department, Mr. Bhattacharya doesn't know.
reply if any.
On the reopening.
Within a 1 week.
After reopening.
After reopening of the winter vacation, after reopening of the court, reopening of the court after winter vacation, comma, reply if any there to be filed within a week thereafter. List the matter on 22nd January.
Will kindly not keep it on 22nd.
Why?
22nd to 26th, I am on a pilgrimage. To Mahakumbh.
Just before he goes to Mahakumbh, my lord, let him agree to my extension. Let me have
16.
So far as GA 5 and 6 are concerned, Lordship,
GA?
that is GA.
In the same.
Yes, in the same suit, because there's a division bench order asking them to disclose certain particulars and disposed of the appeal. They have not done it within that time. So our application is for disclosure of those records and consequential prayer if they do not, special officer will be appointed. So Lordship, kindly, since that involves compliance with order of court, Lordship, kindly fixes that GA6 any day.
GA5, I am for respondent number 33, my lord. But may I file my opposition, my lord?
Very well. GA6 Lordship fixes that because that's compliance with an order of court. So we should, so we want some precedents. Irrespective of, yes, GA6, irrespective of all these applications. GA6 Lordship kindly fixes.
Who is appearing you?
Yes, they are the same defendant.
I am for 33, my lord.
Item number?
Same.
GA5.
The same lot, GA6.
23. 33.
In item number 23, there are several GAs. GA6 is one of them.
In item GA6, counsel for the, you are for the defendant number?
I am for the plaintiff.
You are for the plaintiff. And the plaintiff has, counsel for the plaintiff.
Affidavits are complete here.
There is a direction from the appellate court for disclosure
of certain particulars.
From the appellate court upon the defendant number.
Upon defendant numbers 26 and 27.
6 and 27 for disclosure of some document.
And
till
particulars.
date they have not disclosed.
And particulars.
Disclosure of document and particulars, but till date the same has not been disclosed.
But I am in GS5.
In counsel for the plaintiff submitted, as there is a direction from the Honorable Appellate Court, the matter is to be heard expeditiously. In view of the above, let the matter appear on.
Who
is appearing for the defendant 23?
26, my lord, I am.
23, I am for 23, my lord. I am for
26.
1, 2, 20.
No,
I'm asking
defendant number
26, 27.
26, 27.
Mr. Bhattacharya.
You are appearing. Let the matter. Then why you are not disclosing?
My lord, I have filed an affidavit in opposition.
Lordship, here.
Let the matter appear on. Then you will not be available. On the same day.
First week of January, I am there.
Let GF,
whichever day, let's link this with that one.
Be fixed on 9th of January 2022.
Grateful to
my lord, kindly records.
As regard GF5 of 2022,
number 33.
Document number 33, defendant number 33 has filed affidavit in opposition after serving the copy to the land counsel for the plaintiff.
Yes.
Let the same be cut with the record.
Deeply obliged.
With respect to defendants number 1, 2, 23 and 24, may I be permitted to file my affidavit in opposition to GA8. Similar players which has been made by Mr. Bhattacharya.
GA8 of 2024, counsel for the
defendants number 1, 2, 23 and 24.
1, 2, 22 and 23. Praise for time to file affidavit in opposition.
Liberty may be granted to all the respondents to use their affidavits.
1, 2, 23 and 24.
1, 2, 23 and 24. Praise for time to file affidavit in
opposition to GA8.
Opposition in connection GA8 of 2024. Let affidavit in opposition be filed within 2 weeks.
Lordship was given 1 week after the opening.
After 1 week after winter vacation. Reply if any there to be filed within a week thereafter. Is the matter on 22nd of January.
And Lordship, so far as GA6 is concerned,
क्या date दिया? 16th of January.
So far as GA6 is concerned, there GA5 is concerned. So far, Lordship has fixed it on 8th of January, on 9th of January. Their opposition is out of time, but doesn't matter. Lordship, formally, I shall give my reply by Friday.
Come
by
with the
tomorrow.
reply on that day.
Very well.
Serve the advance copy.
I shall serve it now.
Yes. Call.
Well, this is my application.
Yes.
Application.
Bring your witness. Witness is present. Bring witness. There is no time. My appellate 4 p.m. appellate matter is there.
I think takes up the last deposition.
Where is the deposition?
23rd of September 2024.
Yes. Adjourn.
And thereafter, one general diary has been lost before the Domdom police station on 23rd of March 2022. But at the time of examination, my lord, the original copy was not there. It was with my advocate record. That is the difficulty. And we have annexed, my lord, the general diary that is in page number that is annexed 23rd of March 2022. That is in my probate application.
Yes, then
This is the original copy. We have annexed the photocopy of the general diary dated 23rd March 2022. My lord, witness is here. He is with the original general diary.
who is the who is Pallab Banerjee?
Follow Banerjee was the
No, sorry, witness.
official of the Domdom police station.
He is present today.
Yes, my lord.
You are the Pallab Banerjee.
What is your name?
What is your? Please come on the dock.
He's another person.
What is your good name? To whom you are summoned?
নাম বলুন
নিবাস মন্ডল
মাইকে বলুন
নিবাস মন্ডল
So, whom you are summoned?
There was a direction to bring an official of
See, madam, there is a procedure.
yes, ma'am.
On 23rd September, when Pallab Banerjee was examined,
He's not here today.
he was the whatever it is. You are not taken. What? Yes, he was the ASI. What he was doing? Correct on that day. So you put 4 questions. Thereafter, the case was adjourned.
This is my affidavit of compliances. I have served the notice.
Let hear from court. So his examination was not completed. The case was adjourned.
Yes, ma'am.
Now thereafter, you wanted to bring the original because original was not there. Correct. So bring the original. Now you summoned the other officer. How he has come? As the subpoena has been issued. So how he has come?
As per the order dated 23rd of September 2024, I have made a communication to the Domdom police station to send our official of the Domdom police station so that I can examine that person.
So there is a procedure. You recorded. You have as per this as per the order dated 23rd of September, the police officer has sent them. The concerned officer in charge send the officer. Correct.
Yes,
What will happen to the witness who has not been? His examination is deferred. Whether you will continue with that evidence, then.
yes, madam.
So if you continue the evidence, how this witness will be examined?
But I was not informed that some other person is coming today. Just now, my lord, I have informed that.
So what will happen to this Pallab Banerjee?
Then,
What
my
will
lord,
happen to the Pallab Banerjee?
next date, my lord. So
For
that
what?
in respect of that witness, Mr.
Pallab Banerjee is processed in your police station now.
No,
Pallab Banerjee আপনাদের থানাতে আছে না?
না স্যার অন্য জায়গায় পোস্টিং হয়ে গেছে
অন্য জায়গা আছে কি করব?
স্যার ব্যাকপুর কমিশনারেট পদে আছে
I have to give the notice to the register of original site so that I can.
Madam,
Otherwise, subpoena.
only for that purpose the witness is to come. So you file an application for expunging this evidence and you examine this witness. Otherwise, no purpose would be served. Correct? Yes.
But calling for me also, I can answer.
Expunge this evidence. File an application
File.
or make a oral prayer expunging this evidence will be expunged. Then this evidence can be taken. We will expunging this evidence. Yes, start. Hurry. Only 4-line evidence.
1 minute. বলুন আমি শপথপূর্বক বলছি
আমি শপথপূর্বক বলছি
এই মামলায় সাক্ষ্য দিতে এসে
আমি
যা বলবো সত্য বলবো
সত্য বলবো
সত্য বই মিথ্যে বলবো না
সত্য বই মিথ্যে বলবো না
কোনো কথা গোপন করবো না
কোনো কথা গোপন করবো না
আপনার নাম
নিবাস মন্ডল এএসআই নিবাস মন্ডল
বানান বলুন নিবাস
NIBAS
NIBS মন্ডল
MONDL
MONDAL মন্ডল বাবার নাম
लेट धनंजय मंडल
লেট ধনঞ্জয় মন্ডল কত বয়স আপনার
रुको रुको उसको प्रोड्यूस
আমার
करने दो
44
she will
কি
produce
করেন আপনি
পুলিশ সার্ভিস করি
এসআই অফ পুলিশ
এসআই পুলিশ ওয়েস্ট বেঙ্গল
আপনার বাড়ির ঠিকানা বলুন আস্তে আস্তে
ভিলেজ পোস্ট মাটি কুমড়া
মাটি
কুমড়া
কুমড়া
পিএস রানাঘাট
পিএস রানাঘাট
নদিয়া
নদিয়া পিনকোড
741201
741201 Yes, madam.
The witness, I'm showing you a document dated 23rd of March 2022.
has he received the
Yes.
summon Safina
सर
have you received the Safina
तो सफीना मिला है
है सर मिला है सर
yes I received the Safina
I have received the सफीना
as per the Safina has you brought the document
সফিনা মোতাবেক আপনি কি ডকুমেন্টটা নিয়ে এসেছেন
है सर নিয়ে এসেছি জিডি নিয়ে এসেছি স্যার
yes I have taken the document that GD
what are the document you have brought
কোন সা কি ডকুমেন্ট নিয়ে এসেছেন আপনি
এটা স্যার উইল হয়েছে লস্ট উইল এটা স্যার
GD entry
স্যার
what document you have brought GD entry
জেডি এন্ট্রি স্যার
this is the GD entry of a lost will
what is the number of the GD
নাম্বার কি
1768
1768
what is the date
তারিখ কত
23/3/2022
23 মার্চ 2022
23 মার্চ 2022
have you brought the attested copy of your diary
স্যার
attested copy
অ্যাটাচড
নিয়ে
কপি
এসেছেন
হ্যাঁ স্যার নিয়ে এসেছি
yes I have brought the attested copy of the diary
exhibit
exhibit কত হবে
Date of the general diary মাতে
huh exhibit B exhibit B yeah shown your original
This is the original.
shown the original complaint see the original tell whether this is the complaint which you received which was received by your office
এটা কি সেই কমপ্লেন্টটা যেটা আপনার অফিসে রিসিভ করা হয়েছিল
হ্যাঁ স্যার এটা স্যার
yes this is the original complaint that was received by my office
having the GD number and date
কি সেই জিডি নাম্বার আর ডেটটা আছে
স্যার সেম আছে
yes the GD number and the date are the same
exhibit 4 see anything further that's all no further yes step down
I have already examined the attesting witnesses.
Hmm.
Their deposition is there, my lord, dated 17th of May 2024.
Hmm. Attesting witness
Yes.
Hmm. Will exhibited
Yes, ma'am.
signature exhibited
Everything.
okay fix the date for all sons suffering for the petitioner full stop one witness namely Nibas Mandal is present Nibas Mandal is present on receipt of Safina issued by the master full stop during his evidence two documents were marked as exhibit B and exhibit C exhibit B and exhibit C examination examination of the witness concluded witness is discharged counsel for the plaintiff submitted she will not adduce any further evidence on the side of the petitioner is closed let evidence on the side of the petitioner is closed full stop leaves the matter on 19th December for argument yes call the appellate side
My lord, before my lord takes up the appellate side matter, so can you mention a matter?
for what
Could you explain? My lord, complete the mediation process.
come tomorrow morning
It's there tomorrow. The last date is tomorrow.
there is no problem
It's tomorrow. But it can be. So
My lordship would be taking up hearing matters next week. Hearing matters.
No matter for the original side. Now appellate side will be taken.
No, my lord, hearing matters. The original side hearing matters next week being the last week before vacation, lordship.
No
And
hearing.
may I, my lord, item number 25 and 20, both of us were there, lordship. Keeps it after vacation. It's again a demerer application.
Mention because appellate.
Okay.
It will come tomorrow or next week you mention. I will not take the hearing.
Only one matter I came up today in the morning. I said, actually, hearing it will
No principal bench.
Circuit pictures. But may I be permitted? I'm sorry.
Look. Let it clear. Original side be clear.
Mike.
अरे वो बोलो उसमें ना एक विटनेस एग्जामिन हुआ था PW2 ना ऑन सो डेट और डेट बता दो on so one witness was examined, namely देख लेना उसमें so but his examination was deferred due to non-production of the original document. Now today another witness is present along with the original document. Accordingly, the counsel for the plaintiff petitioner prays for expunging of the evidence of the witness so and so. Considering the submission made by the counsel for the plaintiff petitioner, the evidence of witness namely so and so dated so is expunged.
Lordship.
Yes.
Whether original side matter will be taken up after finishing.
After
finishing.
No, come tomorrow morning.
Grateful, Lordship.
Yes, call. Any mentioning?
My lord.
Yes, what is the mention?
Contempt application.
Huh?
Contempt application.
Order dated? My order?
My lord.
It is filed in the here or the
My lord, in circuit bench. It has been filed in circuit.
call the record.
Date.
Next Thursday.
Date.
Yes, call the matter.
Item number 1. My lord, I appear in with petition.
Yes.
Pursuant to your lordship's desire, my lord, I have subbed the copy of the contempt application upon the alleged contender.
Yes.
It appears from the evidence of the service that has been received by the contender. Yes. An order dated passed by your lordships on 9th June 2023 with the direction to comply the order of the Commissioner of School Education. But till date, my lord, it has not been carried out.
Chairman Jalpaiguri District Primary Council
School Council
to comply with the direction passed by the Commissioner of School Education within a period of 4 weeks on date of receipt of the order. When you communicated, sir?
Yes, my lord.
31st of July.
On 14th June, the server copy was forwarded to him.
14 June.
14th June.
Then
my till date nothing. More than 1 year.
What is the page 20?
Page 20 is the communication.
Again.
Again.
They have not done anything.
Nothing. And even, my lord, after service of the copy of the contempt application, I expected that somebody will represent and some explanation be given to your lordships. Nothing has been covered. Every service has been.
So and so appearing for the petitioner. Petitioner has filed affidavit of service showing the copy of the contempt application along with the document have been duly served upon the alleged contemptor, which was delivered to the office of the alleged contemptor on 19th of December 2024. But in spite of receipt of the notice of contempt,
9th December. 9th December 24.
9th December.
9th December.
In spite of receipt of the notice of the contempt, notice none appears on behalf of the contemptor. The petitioner has filed the present application on the grievance that by an order dated 9th of June 2023, this court has disposed of the writ application by directing the chairman, Jalpaiguri, district primary council to comply with the direction passed by the Commissioner of School Education, West Bengal, dated 9th April 2016, within a period of 4 weeks from the date of receipt of the copy of this order. Full stop. Counsel for the petitioner has communicated the order to the alleged contemner on 14th of June 2023 and subsequent on 31st of July 2023. But in spite of receipt of the order passed by this court till date, the alleged contemner has not complied with the order passed by this court dated 9th of June 2023. In spite of receipt of the notice of this contempt application, none appears on behalf of the contemner. Accordingly, the alleged contemner, namely, who is the
Pranab Rai, the chairman.
namely Pranab Rai,
Oh, let me.
Wait.
Loksa Mohan Rai, the
Is
chairman, Jalpaiguri District Primary School.
Laksha Mohan Roy, chairman, Jalpaiguri District Primary School Council, District Jalpaiguri, is directed to appear through virtual mode before this court on 19th of December 2024. Full stop. The petitioner is directed to communicate this order to the alleged contemner and to file the affidavit of service on the next date fixed. It is
Virtual mode or whether the physical appearance?
Let it be first, because now the Supreme Court guidelines are there. It is made clear if the alleged contemner fails to appear through virtual mode, necessary order will be passed.
Your lordships kindly virtual mode stroke physical appearance. Your lordships can do
Stroke
that.
physical. No,
If,
no,
if they,
let
if
it-
they
let it
want
be
to
virtual.
want to explain, let
If
them.
they will come, let us. Because
No, if your lordships directed to virtual, they will not.
virtual,
Virtual
madam,
stroke or a
virtual,
physical
virtual
or physical.
slash
Physical.
physical.
Extremely careful. Extremely.
Yes, next.
My lords, I appear for the petitioner.
अच्छे तो petition में आते हैं. Petition.
Yes.
My lords, we were supposed to file written notes on the argument.
Ready?
Yes, ma'am.
Record there. So and so appearing for the appearing for the petitioner through virtual mode. None appears on behalf of the respondents. Full stop. The petitioner has filed written notes of argument. Let the same be kept with the record. CAV.
I'm grateful.
Next.
Number 4.
My lord, I appear for the opposite party number 2, my lord.
Yes. Who is for the petitioner?
My lord, even on the last date, my lord, none has appeared. If your lordship kindly sees the order dated 28th of November.
What is a CRAN?
My lord, this, my lord, if your lordship kindly takes up the application, this is a review / recall application of an interlocutory order passed by your lordship.
Pass an order for review or recalling the order dated in connection with the CRR number.
Yes.
What is the order passed?
And this is 21st of May 2024. It's an appeal, it's a revisional application against an proceeding under the Domestic Violence Act. There, your lordship, my lord, on that date, was pleased to direct the husband, the petitioner, to pay the amount which was directed to be paid by the learned trial court. Now, a time frame was fixed, which was not complied with. After the time frame, this application has been filed, and till today, my lord, no amount has been given.
Till today?
Yes, my lord.
So you have not taken any steps?
My instructions are, my lord, that 2 execution proceedings are pending. On every date, my lord, pendency of this application has been shown, and the learned court, in its wisdom, my lord, is not doing anything, my lord. My lord has been pleased to see that order. I have a copy.
So and so appearing for the petitioner. So and so appearing for the opposite party.
Party number 2, my lord.
Opposite party. None appears on behalf of the petitioner. It is fine from the record. The matter was taken up for hearing on 28th of 11, 2024. 2024. On the said date also, none appears on behalf of the petitioner. But for the ends of justice, the case was adjourned till today. In the order dated 28/11/2024, it was made clear that if none appears on behalf of the petitioner on the next date fixed, appropriate order will be passed. Today, when the matter is called, none appears on behalf of the petitioner, no accommodation is sought for. Accordingly, CRAN 1 of 2024, filed in CRR 244 of 2023, is dismissed for defaulting.